stop, see some herds once in a while. You'll stop, see some herds and there's a lot, it seems like there's quite a few cattle that raise on those 35. They all look like, they all look like black ants to me. That's what they're doing. Yeah. Well, it's stands, you can I've been meaning to ask you, I've been talking about it now.
I think they have to deal with it.
New game, that's sort of still semi-new, right?
Yeah.
But that's gotta be so efficient.
Well, but it must
Right.
be efficient, it must be
I
efficient.
understand you're a stance on the one.
Yeah, I was just thinking small.
That's just speculation on my part. I think
Maybe,
that's,
maybe.
if this is.
Constantine, there is
Oh, yeah.
No.
So, countries.
What do you-
It wasn't crazy sure.
I'm just trying to get to the end, so I can pick
I
it.
understand.
And we actually tried to work last year.
Today's, yeah.
And, we're able to.
Get this.
We'll be arguing Sunday, for sure.
Kirk, I was thinking about a corporation commission, 20+ years ago. I met the weirdest experience ever.
Well, it's up there. Kind of forgotten about that.
No cross-examination. no
Yeah.
line hours.
Yeah. We remember that.
You ever see your friend Jimmy Sakura?
You know,
Still around?
it's been a long time. His niece, his brother's daughter, is good friends with mine, so. And, I'll see her. But I haven't seen Jim. I think he still practices law.
Into oil and gas.
Yeah, that's what, he does a lot of that.
This was in front of the kid, this was not, it was, we were representing West Star. Oh, Goodyear plant, yeah, yeah.
It's the public service in Mexico.
Yeah. Yeah, we did. It was over there. It was big. It was like big. Yeah. In their building now. He was, who was the lady that was? Yeah. I sort of, I can never figure out whether she was on her side, this, I'm like, I don't know what you do.
Shifting appliances.
Yes. Didn't or represent some group of this.
Yeah, industrial, some kind of industrial.
Yeah.
commercial users, and for some reason they
morning, please be seated.
Morning, Your Honor.
A lot of technology up here trying to make room. Well, welcome to the May docket of the Kansas Court of Appeals. It's a pleasure to be hosted once again by the United States District Court for the District of Kansas. And we understand we're sitting in a courtroom that may end up being one of our former colleagues' courtrooms soon. So that's exciting as well. You've got some, let's say, seasoned judges on this panel. Today is my 42nd anniversary of graduating from law school. I was 10, I think, if I recall correctly. It's an honor to sit with these two because we were all appointed about the same time to the Kansas Court of Appeals. To my right, your left, Judge Kim Schroeder. He was appointed in 2013 to our court. But before that, from 1999 to 2013, he served as a district court judge in the 26th Judicial District, which involves a lot of counties that I don't know, but I know his home base was Hugoton. And before that, he was, I think, 17 years in the practice of law in Hugoton. And it's a special honor as well. To my left, your right, Judge Catherine Gardner, who was appointed to our court in 2015. She previously served as a research attorney for the Kansas Court of Appeals, as a law clerk for United States District Court Judge Sam Crow.
Judges, you guys okay? We got an alarm in here. Somebody hit the alarm button.
Where's it at?
There's one here, but I didn't push that. I know, this is the panic.
Yeah, well, we're
Yeah,
fine.
we're good.
Well, I just have to reset it real quick.
Okay.
You probably have to go up there. I don't think it's.
Is that it? Well, there's, it looks like there might be one over
Yeah.
This
here.
is the one I know of.
Well, we know they respond.
Well,
Yeah,
thank you
that's
for
nice. Good to
responding.
know.
We appreciate that.
In Seward County, one time I hit the button by mistake, and everybody went to the treasurer's office.
That's the one I know.
You told them the wrong place.
Some more space there.
It's Judge Gardner's fault.
I'm gonna push it.
Well,
Don't worry, you're not the only folks that done that.
Thank you.
Thank you.
Good to know. Great response.
Thank you, appreciate
Yeah.
that.
We don't usually panic when we see attorneys in front of us.
Yeah, they look like a tough group.
They
but not
do.
that
They're
tough.
fierce.
Well, as I was saying, Judge Gardner also was a federal law clerk for United States District Judge Sam Crow, and I mentioned Judge Crow because he would have turned 100 this week, or last
Last
week.
week.
So, he liked to play pool at Terry's in Topeka every Tuesday with his son Dan, so that was always fun. Catherine was also an assistant attorney general, a litigator in private practice here in Wichita for many years, and a former high school English and French teacher.
Right.
So très bien.
Bonjour.
With that, we have 3 cases on this morning's docket. The first 2 may seem like deja vu after a while for those who are not involved in them, but they have a little differences between the 2, but a lot of similarities as well. And those are the 2 Element LC cases. And then, I don't know, is it pronounced Rain or Rainy, the next case? Rainy, okay. So those are our cases. As I think all of you are seasoned appellate attorneys, you have 15 minutes per side. The appellant, if they would like rebuttal time, let me know that up front, and you can save some of your time for rebuttal. You've heard our spiel before, but we have read the briefs. We've read a lot of cases. We've read pre-hearing memos supplied by our research attorneys. So if you want to talk about facts, that's up to you, but if you want to get right into the legal questions, that is fine as well. As Andy Reid says, it's your time. So use the 15 minutes wisely. It can often go quickly. But with that, we'll go ahead and call the first case. Element LLC, Applee versus Rodney Harris et al. If you would please state your appearances.
Kirk May, Your Honor, on behalf of the appellants, the defendants below, Mr. Harris, Crowley, Simmons, and Walls.
Okay.
Good morning, judges. May it please the court, Matt Geiger appears for plaintiff Applee Element LLC.
And Mr. May, do you want to reserve any time for rebuttal?
Please, Your Honor, 3 minutes, if that is appropriate.
That's fine. So
Thank you.
12 and 3, and let me get my cell phone out. I won't be texting or being on Facebook, but I will use it as a clock. So let us do that. If you want to come on forward. And you may begin whenever you're ready.
Thank you. May it please the court, Your Honor. Kansas Statute 17-7663 expressly provides that a manager of a limited liability company is to be treated as though they are bound by the operating agreement of an LLC, even if the manager doesn't sign it. The appellants in this case were managers of Element. The statute also provides that Element itself, a limited liability company, I'm quoting now, is bound by its operating agreement whether or not that limited liability company executes the operating agreement. The upshot of the statute is a manager or the limited liability company itself is treated as having actually executed the agreement. I describe it as they statutorily executed. And interestingly, the same statute also applies to a member. So a member, even if they don't execute an operating agreement, is nonetheless treated as though they have. And that's the thrust of the statute. Element, the LLC, therefore, was a party to the operating agreement, as were the managers a party to the operating agreement.
And your clients are managers, not members, correct?
Managers, correct, Your Honor.
But their duties were defined in the operating agreement.
Yes, Your Honor, and in fact, there's a specific provision in the operating agreement that defines the fiduciary duties. That very same provision is quoted in the plaintiff's below, in the petition, okay, and is one of two paragraphs where the plaintiffs say in their petition, the defendants, the appellants in this case, breached their fiduciary duties.
So is it your position that their claim, of course we can ask them about their own claim, but is it your position that their claim arises at least in part out of the operating agreement and the fiduciary duties owed by the managers?
Absolutely, Your Honor. That position again is, when you look at the petition, you'll see the operating agreement referenced frequently through it.
There's some argument though that they're just trying to enforce a common law fiduciary duty. So help me understand what you see the distinction here is in this case, if any.
Well, this may be a case where there's no distinction between the two substantively, maybe, but what they have pled, Your Honor, I believe it's in paragraphs 88 and 88 through 90 of the petition. They have specifically pled that provision, Your Honor, asked about that defines fiduciary duties for the managers, and has said those fiduciary duties have been breached. Given
and the operating agreement, just to cut to the chase, I mean, there's all kinds of other agreements, but the operating agreement does require arbitration, is that it?
It does, Your Honor. There's no dispute about that. And the arbitration provision in the operating agreement uses the typical, but nonetheless, as the Kansas appellate courts have observed, broad language of any dispute, controversy, what have you, arising out of or related to the operating agreement. and the manager's authority and their requirements, things they have to do, flow directly from that operating agreement. They're only managers by virtue of the operating agreement.
So let's say we agree with that part of your position. Then we get to the order, the receivership order.
Yep.
And does it not provide that even though, let's say the operating agreement controls arbitration would generally be required, but doesn't it still require leave of the district court?
I would not agree it requires leave necessarily, Your Honor. We sought leave in this particular instance to ensure that we were complying with the receivership order. But more importantly, and I should note, the district court's ruling below was premised, and at least at one point in one of the premises, if you will, was that Element was not a party to the operating agreement. And that is legal error because of the statute. And the district court's not free to disregard the statute and under the guise of exercising discretion. For example, the receivers, I'm sorry, Your Honor.
Well, you would agree an abusive discretion standard governs our question here today?
In this sense, Your Honor, that as a matter, if in exercising one's discretion, there is a legal error in which the discretion is based, then that discretion has been abused. And I think the court's cases are clear on that. That's the situation we have here. First example, Element's not a party to the operating agreement, or the managers aren't parties to the operating agreement. It's a legal question. There's a statute. The statute makes them a party.
But you would agree, though, and certainly one way you can get abuse of discretion is a mistake of law. But so you've stated that certainly correctly, but it is a discretionary call, assuming that the facts are applied correctly, the law is applied correctly, and it's reasonable. It is a discretionary call for a district court to decide whether to grant a party leave to do something.
I can't say generally whether that would always be the case or not, Your Honor. In this particular case, I can say that there was a provision, it's section 15B of the receivership order, it's in the appendix to that, that provision does provide, begins with, without first obtaining leave of court. And that's what was done in this case. And the provisions on which the court relied principally, and on which the appellees rely on this appeal, are found at 15B, little I, Roman I, and Roman 4, okay? And then 6D. And if I might, 6D, Your Honor, again, in interpreting these and applying these, okay, you can't base your decision on a legal error, right? You cannot, well, you can, and if you do that, it's an abuse of discretion.
But we can affirm for any reason if they reach the correct result.
Well, there has to be some evidentiary basis, with all due respect, Your Honor. I don't think you can,
Sure.
yeah,
Sure.
and there is none here.
Why doesn't 6 give us that authority?
Well,
6D.
okay, because 6D says the receiver, okay, shall not be bound by any contracts, agreements, or other commitments of Element or the receivership businesses, or any of their respective directors, equity owners, agents, employees, or other representatives. Those are managers included in that, okay? So what that says is managers, representatives, okay, who have a contract with a third party, right, are not bound to follow that contract, because they're just like the receiver in that provision. So that provision, I don't find any ambiguity in the construction of it. Otherwise, I believe would be legal error. Essentially, the same rules that would apply to interpreting a contract.
So you would simply say that 6D, because it's talking about contracts with third parties, does not apply to the operating agreement or any of the other agreements that
I-
were entered into here?
Yeah, I would say by its terms, it would not apply to certainly the operating agreement and any agreement in which a director, equity owner, agent, employee, or representative of Element, okay, is the party. So those people under this under this provision can't be a third party, because they're talking about the third parties are people who the managers in this instance, or Element in this instance, have contracts with, that are not one of these. It doesn't apply, for example, if you had a manager versus manager, right? Because they can't be third parties under the literal language of 6D. 15B, Your Honor.
And let me make sure I understand
okay.
what you're arguing there, that because they are managers, they are created by the operating agreement, their duties are expressed in the operating agreement. Because of that, they cannot be third parties to the agreement. They're controlled
Well,
by the agreement. Is that?
That's true also, Your Honor. They also can't be a third party by virtue of that. But
That's why I was trying to figure out why are you saying that they can't be a third party?
well, because they're a party to the operating agreement. So they've got to be outside the operating agreement to be a third party vis-a-vis the operating agreement, right? Well, just like a member who doesn't sign it but is treated as executing the agreement is not a third party. But more specifically, the literal language of 6D, okay, is a different way, I guess I would describe it, Your Honor, of getting to the same place. And it makes clear that if you're a representative or agent, like a manager would be, okay, they're talking about situations that manager has with a third party. So this provision does not apply to managers, because it's talking about Element and relationships it has with third parties. Okay, and an Element and the manager under 6D are essentially in the same position.
How do we then handle 15B4, I think it is?
Well,
The district court has exclusive jurisdiction over receivership property. Now, I'm not quoting, but I'm paraphrasing.
understood, Your Honor.
But how does that play into all of this?
Well, the motion to compel arbitration in the arbitration procedure, okay, does not interfere with the jurisdiction that the district court has over the property, the asset, if you will, the cause of action in this case, right? And we know this, that there,
I guess I don't understand that statement, because the concept of arbitration is to resolve the issues.
well, the
Wouldn't that be
form.
taking it away from the court and the receivership?
Well, you haven't taken away from the court the exclusive jurisdiction to manage the property of the estate. In other words, for example, there could be, the receiver may have a claim against some vendor in Colorado, okay? And they can't make that Colorado come to Kansas and litigate in Sedgwick County.
But you do agree this claim would be receivership property.
Don't dispute that, Your Honor.
And when we we do it all the time, and we do it too, we throw around the term jurisdiction. What type of jurisdiction are we talking about there? I think it in rem jurisdiction. Is that
Well,
what we're talking?
I think in the receiver context, it's most appropriately viewed as over the property, the assets of the entity that's in the receivership.
And
which
certainly the district court could have ordered binding arbitration either under this, could order other forms of alternative dispute resolution. I guess our question boils down to, did the district court have to do that?
And on that issue, Your Honor, again, the district court, okay, given all the body of law in the Federal Arbitration Act, which all the parties agree governs this, the district court can't ignore an arbitration clause that's enforceable. and enforceable under the Federal Arbitration Act. Just as a matter, I'll say supremacy, but can't apply the Federal Arbitration Act. If the denial of the motion to compel is inconsistent with that, which I think it is, that's a legal error that the district court committed. And again, it's almost an argument that the appellant makes, I think fairly viewed, is some fashion or another, the appellants waived their right to arbitrate, right, by agreeing, although I should note the appellants in this case, they're not parties to they weren't parties to the receivership, they didn't negotiate but they are managers of Element.
And they certainly affect the property of the receivership.
That's the allegation, yes.
Yeah.
That's the allegation.
I need to tell you, you're almost to 15 minutes, so why don't you wrap this part up, see if we have any questions, and I'll give Mr. Geiger a little
Okay,
extra time if he
okay.
needs it. But he's probably going to argue twice anyway, I don't know.
Okay. Let me just address briefly, Your Honor, the other bases the court found, and it revolves around this master services agreement and the notion that somehow that was the last and best expression of the party's intent. Just to frame the time, keep in mind, at the time that master service agreement was executed, there was also an amendment to the operating agreement. Okay? The original operating agreement we talked about was executed in March of 2018. Fast forward to December of 2020. Okay? There's an amendment executed, and the amendment even refers to the master services agreement and says in section 1D, and it says there that contemporaneously with this amendment, we're also executing this master services agreement.
That's a management services agreement?
Yes, I'm sorry, management service agreement, correct. So they're contemporaneously being exercised, okay? The amendment expressly says what provisions are being amended, and it expressly provides that the members have sought and obtained the supermajority vote of the board, which under the operating agreement is required before there can be any amendments to the operating agreement. Has to be agreed to by a supermajority of the board, which wasn't the case, not indicated on the management services agreement. These documents are executed contemporaneously, and most importantly, the amendment, Your Honors, expressly provides, no implication necessary, expressly provides that all other provisions of the operating agreement remain unchanged and continue in full force and effect, which obviously would necessarily include the arbitration provision in the operating agreement. And any construction, Your Honor, that would impute an amendment to or a change to the arbitration provision would be unsupported by the evidence, frankly. Would just be erroneous. And it's also significant the management services agreement itself provides in section 10B, Roman 2, that nothing in that agreement contravenes anything in the operating agreement. That's amended at the same time, and that is made clear that all provisions in that operating agreement remain unchanged.
Do you have any questions? I don't. Okay, we'll go ahead and give you a little rebuttal time.
Thank you, Your Honor.
Mr. Geiger will be flexible in the time, and as our former colleague, Judge Joseph Perrin used to say, if you don't want to use all the time, we're not going to penalize you. But we will give you a little extra time in light of.
Very good, judges. Thank you for having me here today. This is one of the still joyful things that lawyers get to do, is come to court and argue, and it's more and more rare. And so I still get, after 30 years, a bit of giddy excitement. So I hope you'll bear with me. One of the great lessons that Mr. May taught me when I worked for him was attention to detail. And I'm going to honor that lesson today by starting with 17-7663, which is where he started his argument in subsection M. The entire argument of appellants is based on a faulty premise, that the managers are parties to the operating agreement. That's not what the statute says. The statute says a member or manager of a limited liability company is bound by the operating agreement, whether that member or manager signs or not. But it goes on to say an operating agreement may provide rights to any person, including a person who is not a party to the operating agreement, to the extent set forth therein. So, what rights does the operating agreement give them?
Now, who are we talking about then?
The defendants, the managers.
All right, just want to make sure I was following you.
Thank you, Your Honor. Record Volume 2, page 48, is third parties. This is what rights the operating agreement gives the managers. Nothing herein expressed or implied is intended or shall be construed to confer upon or give to any person or entity other than the parties to this agreement and their respective successors and permitted assigns any rights or remedies under or by reason of this agreement. So when you read the statute together with the third party provision in the operating agreement, it's clear the managers are not parties. Parties is a defined term, and it doesn't include the 4 individual defendants who are appealing today. They don't have any right to compel arbitration under that operating agreement. And we'll talk about Hemp Hill in a second.
Well, you're making now, with attention to detail, you've now convoluted 2 different arguments. You're saying that the managers are not members, therefore they're not parties to the agreement. That doesn't necessarily mean that they couldn't be third-party beneficiaries to the arbitration clause. But I assume you have an argument why they are not.
Record Volume 2, page 48, third parties. They're expressly excluded under the operating agreement. That third-party language doesn't give any rights or remedies, including the right to enforce an arbitration clause, to the managers.
Even if your claim, and we're going to talk about this in a second, you probably anticipate this, even if your claim, let's say your claim was solely based on the operating agreement against the managers, and certainly in part it is, and that seems to be a little convoluted because we don't have any record to review. This is early in the case, but it appears in your petition that you're arguing that you're trying to make, I think, a common law breach of fiduciary duty claim, but you cite as support of that back to the operating agreement and the fiduciary duties owned under that, which under, I know Hemp Hill is not binding on us, but certainly it could be persuasive to us. Professor Lieben wrote it, if I remember right. So, but he really hung his hat on the arising or related to part of it. Does this claim arise or relate to the operating agreement?
It clearly relates to the operating agreement because there are petition allegations about the operating agreement, but the cause of action stated is breach of fiduciary duty under the common law.
Is that simply to avoid arbitration, or why would you cite a specific source for a duty if that's not the claim you're making?
Because if I would have sued these defendants for breach of contract, you know what their defense would have been?
I think I do.
We're not parties to the agreement. And they would have won a motion to dismiss because they're not parties to the agreement.
At least you wouldn't have arbitrated.
And they would have been able to dismiss. And so that's why they...
But it does seem like, and I recognize that's a sound legal tactic, but it seems like, we can't get concerned too much with what the legal gymnastics going on. That's why we have 2 professionals here. What we have to be concerned of is what is really the basis of this claim. And certainly part of the basis of this claim arises out of the operating agreement and the fiduciary duties owed to the manager. The managers wouldn't have any fiduciary duties, would they?
They would.
Well, how would they even become managers but for the operating agreement, which allows managers? Not all LLCs have managers.
If there was no written operating agreement, and an LLC can exist without a written operating agreement in Kansas.
Thousands of them.
If there was no operating agreement and it was a handshake deal between a bunch of buddies and one of them decides to be managers and there's no rules written down anywhere about what that manager is supposed to do, that manager owes fiduciary duties to the entity and to the members. And those are a creature purely of common law.
Now, and I don't think you were trying to limit it to that, but you said if one of the members I mean, there's a difference between a member manager, a managing member, versus a third-party manager.
But the fiduciary duty is the same. The
So
manager.
you're saying that even though you put it in the petition, you're not trying to make an allegation that the fiduciary duty that you claim was breached arises out of the operating?
I think that it arises under the operating agreement or it arises under common law. I think you can look at the Kansas case law on fiduciary duties that managers owe the LLC, and everything that's in that petition would exist independent of the operating agreement.
It could, but here you're arguing that it does both. And you're trying to sidestep well, I don't know if you're even trying to sidestep, if you're putting it in the petition, the obligation, fiduciary duty under the operating agreement.
The operating agreement does not give these individual defendants any rights to compel arbitration. Set aside for a second, the receivership order says they're enjoined from doing this.
Well, and we do need to get to that.
They're enjoined from doing this. And the most recent expression of the party's intent, as found by the district court, was the MSA. If we even get to the operating agreement, which is third in line in our argument,
So the receivership order should control according to you.
the receivership order should control.
And and I think I started it, my questioning with Mr. May, the receivership certainly leaves it to the discretion of the district court whether to compel arbitration or not. Is that an abuse of discretion standard, as Judge Gardner asked? And if so, was discretion abused in this case?
It was not. The district court considered the briefs, conducted oral argument, and this is probably as good a time as any to talk about Judge Gardner's opinion in dueling, which comes into play here. A motion to enforce an arbitration agreement is a summary judgment type process for the party seeking arbitration. The appellants had the obligation to prove an enforceable arbitration agreement with element. And the district court looked at all the papers, heard the argument, and reached the conclusion that there was no enforceable arbitration agreement. The Court of Appeals presumes the district court made all necessary factual findings from the evidence to support its decision. The court found defendants did not meet their burden, and this negative finding is only disturbed on appeal absent, and I'll have to read this because I don't want to get it wrong, arbitrary disregard of undisputed evidence or some extrinsic consideration such as bias, passion, or prejudice. So if there was supposed to be some findings of fact, it was the appellant's obligation to ask for it, and they didn't.
And the journal entry refers back to the bench ruling, correct?
It does.
Okay, so whatever, usually in a civil case, what's said on the bench stays on the bench, but once there's a journal entry incorporating it, that's where we look at the findings, and if we needed additional findings, you're saying there should have been a motion to supplement the findings.
That would have been up to the appellants. The Master Services Agreement, Management Services Agreement, MSA, the MSA, is the last effective dated document. So there's been a lot of argument in this case about who signed what when. All that matters is the effective date of these agreements. And the latest effective date, there's no dispute about this, is the MSA. And the court looked at the MSA, concluded it was the latest manifestation of the party's intent, and that finding cannot be overturned absent arbitrary disregard of undisputed evidence or some extrinsic consideration. And none of that's before the court. So the appellants lose on the receivership order, which enjoins them from doing what they've done. They can't show an abuse of discretion in the court following and implementing its own order, which is a matter of discretion. They lose on the MSA because it's the most recent document, and it says all disputes are in Sedgwick County, Kansas, not in arbitration. And even if you get past the two of those, this case is different from Hemphill because in Hemphill, the parties entered into a contract that specifically said third parties can compel arbitration. Our contract, the operating agreement, if you assume that is the operative contract, says third parties don't have any rights at all. It's a totally different provision, and so the whole estoppel argument falls apart on the difference in that provision. Estoppel is inducing somebody to believe something and then it being unfair when they believe it.
Now, would the district court have had the discretion to order the parties to participate in arbitration?
To get there, the court would have had to find that the MSA was not the latest expression of intent, would have had to agree with appellants that the operating agreement was the latest expression of intent, would have had to ignore the third-party beneficiary provision in the operating agreement, and would have had to stretch Hemphill beyond what it is now just to promote arbitration. And I understand there's a lot of favoritism.
And that's
for
also
arbitration.
because, well, certainly we're to favor alternative dispute resolutions, including arbitration. Of course, arbitration is a little different because it's binding. Certainly, a district court could order the parties, well, the district court could appoint a special master. The district court could order mediation, probably even what we loosely called in Shawnee County conciliation for recommendations. But it seems like what you're arguing is that it's just that the district court would not even have the discretion to order binding arbitration. Is that what you're arguing?
No, Your Honor.
Okay.
What I'm arguing is to get to that conclusion, the court would have had to clear several obstacles that the court didn't make findings of fact.
And it's difficult because it's so early in this case. And I understand arbitration has to be, well, to be any effective, to be less time, less expensive. But I mean, we don't have much of a record to go on. We have the various different documents, but we have no underlying facts to speak of.
Well, here's what we know from the record, and we can find this in the transcript. What we know is the court exercised discretion under the receivership order and concluded that the MSA was the most recent statement of the party's intent, and that called for dispute resolution in the District Court of Sedgwick County, Kansas. That's what we know. And for the appellants to overcome that finding, they have to prove arbitrary disregard of undisputed evidence or some extrinsic considerations such as bias, passion, or prejudice. And they don't have the record to do that. And that's why the district court properly denied the motion to compel arbitration, and that decision should be affirmed.
Questions?
Thank you.
Thank you. And Mr. May, I'll give you a couple minutes here.
Your Honor, on the receivership order issue, again, the basis articulated by the district court, and it's in the transcript, which is part of the order, okay? Clearly, the court's basis are stated. There were no findings of fact to be supplemented. Those were legal conclusions that the district court drew from two documents, okay? The management services agreement, the amendment to the operating agreement, and I'll even add the operating agreement. Okay?
So we can interpret, if that's all we're talking about, we can interpret it just as well as the district court. And which is maybe why Judge Gardner, in her illustrious opinion, said it's treated a lot like summary judgment, because that's what we do in summary judgment. We love district courts, especially the two of us, since we're former district court judges, but the reality is we can look independently at those written agreements.
That's correct.
And interpret.
That's correct.
Now, we may or may not agree with your argument, but we have that, not discretion, but that's our authority. Okay.
Agreed.
What's your argument to counsel's claim that you failed to ask for specific findings of fact?
Well, there were no specific findings that to be made, frankly, Your Honor, because the evidentiary record before the court were the three documents I just identified. And her conclusion, the district court's conclusions, okay, are, as the judge has said, essentially ones you can reach de novo, that's your scope, and there were no findings to I mean, the dates were the dates, right? And there's a created date in the amendment, there's an effective date in the management services agreement. The amendment was signed first, then the day later. But the amendment says these are contemporaneous agreements together. That's contemporaneous agreements, right? So whatever the minute-by-minute chronology might have been, one could not reasonably conclude that at the same time I'm doing the amendment and I'm saying nothing else has changed in the operating agreement, that we're making this fundamental change to the operating agreement, which is we're deleting the arbitration provision. That's not a reasonable conclusion to reach from the record before the court and before the evidentiary record in the district court. On the receivership order, Your Honor, again, it's not an interference with the exclusive jurisdiction. Okay? It's a different forum to which, under contract, okay, a party was entitled to. And it's not, there's no dispute really, there was an enforceable arbitration provision. Okay? That's not really a question. The issue is, what impact, if any, did or could the receivership order have on what is plainly an arbitration provision that covers this dispute in this case? Okay?
But once in a receivership, once the court, basically the court in a way is the ultimate receiver, because everything now is under the control of the court. At the very least, it seems the court at that point, for lack of a better term, owned the cause of action, owned the claim made by the receiver. And so certainly, you know, you could argue, and you have, that the court abused its discretion, but it seems like it has, if it's the one that now has the kind of the, for lack of, again, better term, in rem jurisdiction over that property, including the claim, that it has to make that first call about whether or not it's going to grant leave under the terms of the receivership for you to pursue your claim to right to arbitration.
Well, but if there is an arbitration agreement that's enforceable, and given the...
Well, and who can enforce it is really a big issue here.
Well, the parties agreed in that sense, yes. Who can enforce?
Because I don't think anybody doubts that that original operating agreement had an arbitration clause.
And I'm saying, and the
Yeah.
parties get the benefit of that, or the obligations of that. And counsel's argument on third parties essentially was, well, assume that Element's not a party, and assume that the managers aren't parties. So, in my judgment, don't follow the statute. Assume that, well, yeah, then they are third parties. But they're parties to the agreement by virtue of the statute.
I've given you about 20 minutes total to argue, so why don't you take about 30 seconds
Okay.
and wrap it up if you would.
On the receivership order again, Your Honor, think of this kind of situation. So, there's a claim the receiver has, Element has. Element brings a claim against whoever, vendor, whoever, and it's removable. Okay? Can they remove it? Does this receivership order preempt the federal removal statute that gives everybody a right to remove their case to federal court? I think not. And I think this is much like that. So again, I think there's a legal error committed, but I don't believe that the receivership order, by its plain literal language, overruled, to borrow the language from the district court, overruled the arbitration agreement.
Well,
Thank
thank
you,
you
Your Honors.
both. Good
Thank
arguments by both counsel. We'll take this under advisement and try to get an opinion out as quickly as possible so you can go wherever you're going to go. Something tells me this isn't going to end here, but if you want to talk settlement in the hallway, feel free. And now we got to figure out who the parties are for this one. So Mr. Geiger looks to be exiting stage left. So now we will go to a case that's going to sound somewhat similar for those watching at home. Element LLC versus the Andersons, Inc. et al. If you'd state your appearances for this case.
Yes, good morning, Your Honors. Tim Davis on behalf of the appellants, defendants below. Thank you.
Morning, Your Honor. Stan Blagan on behalf of the appellant and all the appellants.
Mr. Davis, would you like to reserve any time for rebuttal? And you see, we're somewhat flexible, but we've heard a lot of arguments, so hopefully we don't have to repeat everything. But would you like to reserve a little time for
Oh,
rebuttal?
sure. How about 2 minutes, Your Honor?
2 minutes, so 13 and 2. That's my highest and best use as the PJ, is to keep track of the time. And obviously, I did not do a very good job the first.
You might get fired, huh?
Yeah, I might get fired. That's okay.
As the timekeeper.
You may proceed.
Thank you, Your Honors. May it please the court. Judges, I have the virtue of going second. I tried to learn a few things listening to the arguments.
You might anticipate some of our questions even.
Perhaps, or maybe I'll be way off. But I do want to dive into the receivership order shortly because the panel seemed interested in that. But first, even though I appreciate you all have studied the briefs, I want to give just a tad bit of context that I think is important to examining the receivership order. Element, the plaintiff, acting through the receiver, has sued my clients, the Andersons, Inc., and its subsidiary, the Andersons Ethanol LLC, has sued my clients under 4 agreements, expressly brought suit against them, under the operating agreement, the grain agreement, the ethanol agreement, and the feed agreement. All 4 of those contracts have broad, mandatory arbitration provisions that require arbitration of any claims, any disputes actually, related to those contracts. There really is no dispute about that. And so then the question becomes, is there anything that has happened later on that undoes or overrides or supersedes those unambiguous and broad arbitration provisions that apply here? And I think it's important as we approach that issue to bear in mind the Federal Arbitration Act, which both sides agree applies here, which commands, if there is any doubt about what should be sent to arbitration, those doubts must be resolved in favor of sending the claims to arbitration. So with that framing,
And then the arbitrator could decide whether it's appropriately there or not.
that is exactly correct, Your Honor. If there are disputes about scope, the arbitrator.
Because your case is a little bit different to the extent of the claims being made. I know there are the multiple breach of contract claims, but there are also several other claims as well that may or may not arise out or related to the agreements. Are you saying that all of these claims would have mandatory arbitration? Is that your position?
So yes, Your Honor. Your Honor did hit the nail on the head. The scope issue and whether something is in or out is for the arbitrator to decide in the first instance. However, our position is indeed that the entirety of the receiver's complaint against my clients should be sent to arbitration. You're correct, Your Honor. There are many counts, I think 12 or 13. As I mentioned, there are at least 4 counts, 1, 3, 12, and 13, that expressly claim breach under these 4 contracts with arbitration provisions. But beyond that, Your Honor, when you boil down the receiver's complaint against my client, it's that Andy, which that's what we call the Andersons, Inc., and its subsidiary, Andy Ethanol, the Andersons Ethanol LLC, essentially in violation of the operating agreement, used their alleged position of dominion and control to force Element to enter into the grain, ethanol, and feed agreements. And then my clients used those contracts to allegedly extract, I'll just say, millions of dollars from Element. So Judge, when you boil down the petition, it's really all about using these 3 operational contracts, the grain, ethanol, and feed agreement, to allegedly take money out of Element in violation of Andy Ethanol's duties under the operating agreement. So that was somewhat a long-winded way of saying, Your Honor, yes, we believe all of the counts that really hinge on that central allegation ought to be sent to arbitration. But again, the arbitrator can then decide scope, and if there is some question, the arbitrator gets to sort that out, and our position would be any claims that the arbitrator sends back to court ought to be stayed while arbitration continues. So To dive into this receivership order again, I think we need to approach it from the context of we have these unambiguous 4 contracts, and is there anything later on that undoes them or overrides the arbitration provision? Just start from the most general.
Let me back up a minute when we talk about the receivership, or excuse me, yes, the receivership order, which is not in our record on appeal. And I know the parties have said, yes, it's okay to take judicial notice of it, but we denied a motion to add that document to the record on appeal. So why should we take judicial notice of it?
Well, Your Honor, I think it's allowed under the Kansas statute that dictates what a court can take judicial notice of. It is an order issued by a court of this state, and so I think it's permissible for the court to take judicial notice of it. And I'm not sure if this is where Your Honor is going, but I would say, and in all candor, we said in our brief, the court ought to take judicial notice of it. We agree with the other side on that, but if for some reason this court found that you cannot look at the receivership order, then our view is we win, because what's in the record are the 4 contracts with the unambiguous, broad, mandatory arbitration clauses. So again, in all candor, we took the position, and we stand by it, that the court may and should consider that receivership order. But if the panel in its wisdom finds it cannot consider that, what's in the record are the 4 contracts with arbitration clauses that without doubt apply to and cover the claims that the receiver has brought against my clients.
Can you start with section 6D of the receivership
I sure
order,
can.
please?
Yes, Your Honor. So 6D, sorry, let me get there. I think it's important to note the title of Section 6 of the receivership order is Third-Party Matters. This is on page 15. And if you look at 6D, there's an important qualifier in there in terms of what the receiver shall not be bound by, and it comes in the 4th line. And by the way, I didn't draft this receivership order. It's in the 4th line, it's contracts with third parties. Right? Those are the only types of contracts, at least under 6D, that the receiver can choose to get out of, so to speak. So let's think about the contracts at issue here. The grain, ethanol, and feed agreements are contracts between Element and Andy. And so the question is Andy a third party for purposes of this receivership order? If Your Honors turn to the first page of the receivership order, it is very clear that Andy is not a third party. It is a party to the case in which this receivership order is entered, and it is defined as such. It makes no sense to say a party is a third party. And even if we indulged in that interpretation, there are reasons in the record that reveal why it just cannot be that the receiver supposedly disavowed these key contracts with the arbitration provisions, and that is because the receiver has sued us under them. Clearly, the receiver believes these contracts are still in force and are still valid. You cannot sue under a contract that you have supposedly disavowed by virtue of a receivership order. And more than that, although I don't think we need to get there, there is a provision in this 6D that talks about affirmative written ratification. And obviously, the receiver acts through its counsel, and by filing a pleading in court, pursuant to Rule 11, I think that, if anything, is ratification of that these contracts still exist. You can't sue for the benefits of them and simultaneously avoid your obligations.
Maybe I'm misunderstanding something, but didn't all the parties consent to the receivership?
That is correct, Your Honor.
So then if the parties consented to the receivership, why are you now objecting to the receivership acting?
Well, Your Honor, we're not,
And maybe I'm misunderstanding something here.
you're not, Your Honor. The receivership order entered in April 2023 was done, I think, technically without objection from the Andersons. But yes, we agreed to the terms of the order. A lot has happened in the underlying receivership case since that order was entered. And so I don't want to take an official position about whether or not my clients think the receivership should still be continuing today. But for purposes of answering your question, Your Honor, we're not trying to say this receivership order that we agreed to should be wiped away by this court. We're saying under the terms of it, the receiver's position that we're not allowed to exercise our contractual right under agreements that have not been undone by this receivership order. We're just disagreeing with the position that this order supposedly accomplishes that legal effect. Our position, Judge, is if you read the terms of this order, there's nothing in here that undoes or overrides the plain, unambiguous, broad arbitration agreements in the 4 key contracts at issue.
Well, the one thing that might, and we talked about it earlier in the prior case, the one thing that might is the fact that you have to, before you wouldn't have to seek leave of the court to go to arbitration. But even assuming you're correct, this receivership, which your clients, in this case, are parties to, unlike the prior case, does require leave of the court.
Well, Your Honor, we respectfully disagree for a couple of reasons. I think before you get to the question of must we obtain leave, you have to ask, is something that we're doing by seeking to compel arbitration prohibited by any of the subparts?
Well,
of
no,
Section
you've
15?
got to ask whether the claim against your clients is property controlled by the receivership. And if it is, then it's under the in rem jurisdiction of the district court, and so to enforce the binding arbitration, you need leave, it sounds like to me. I
Well-
mean, if we're looking at plain language,
Here's how I'd put it, Your Honor. Exclusive jurisdiction, okay? What does that mean with respect to the district court exercising its jurisdiction? I think a plain, ordinary reading of that is at the end of the receivership process, whatever money, whatever assets are there, the district court gets to decide how those are disseminated and divvied up among the various creditors and stakeholders of the receivership. And so when you think about how...
isn't that reading something into the plain language that's not written in it?
Well, here's another way I could make the same point, Your Honor. Does exclusive jurisdiction, does that concept allow the district court to go into the parties' contracts and start rearranging their rights and obligations? Certainly we would agree, I think, I don't mean to be presumptuous, exclusive jurisdiction wouldn't give the court the right, for example, to say, I'm going to change the price of corn as set forth in the grain agreement. Well, by the same token, the court has exclusive jurisdiction over these claims in the first instance, right? The receiver has brought them before the district court where that
But the
exclusive...
receiver could do just what you said that the district court couldn't do. The receiver is now running the company. And I'm speaking in general terms, now, not necessarily this case. That's part of what a receiver does. If a receiver comes into a law firm, of course they have to go into each file and make professional judgment decisions. But here we're talking about who has the ultimate control over the property of the receivership. And that's where it seems to me that and again, the court could have granted leave. And I don't know why the court didn't grant leave, maybe, but the court didn't grant leave. And it seems like, in a way, we're putting the cart in front of the horse.
Well, let me take one more shot. at it,
Okay,
Judge.
take another stab at it.
You know, look, I think this idea of exclusive jurisdiction, the claims were brought by the receiver in front of the court where the exclusive jurisdiction lies, and then the court has the obligation to carry out and follow the contracts as they're written, right? And that's exactly what's happened here, and that's what we've asked for anyway until we submit respectfully the district court made
Well, and
error.
you may still, let's say it stays in district court. You haven't lost any arguments. The only thing you probably lost here, and I don't know why both sides would agree to some type of alternative dispute resolution, the only thing you've really lost here is the ability to save some time and some fees. Because you're going to get either, whether it's the district court makes the decision or the arbitrator makes the decision, you haven't lost any arguments here. I mean, this is all very preliminary.
You are correct, Your Honor. We have not lost anything on the merits at this point, but we submit that the right, the contractual right to go to arbitration is an important right.
Oh, I don't doubt that at all, and I think the parties ought to agree to it, but
Yeah.
that's not my decision to
Sure.
make.
Absolutely, Your Honor, but it is an important contractual right that the FAA, the Federal Arbitration Act, says we need to lean into. We need to resolve doubts in favor of arbitration. And so as I see it, Your Honor, the claims were brought in front of the court with exclusive jurisdiction, but then the district court has the obligation to follow the contracts as they are written. And the contracts as written say we must go to arbitration. I know I can tell I'm running short on time.
Well, you're about 14 minutes, so I just want to make sure that they didn't have any more questions. If you want rebuttal time, certainly you can But go ahead and
Ma'am,
wrap this part up.
I'll just make one more point,
Sure.
Your Honor. Let's just assume we live in the world where 15B Romanet 4 applies and we need to seek the district court's leave. And while we don't agree with it, let's assume, to Judge Gardner's question earlier, that it's an abuse of discretion standard, right? As my colleague, Mr. May, articulated in his argument, let's think about the reasons that the district court gave in the transcript from the bench ruling. This notion that the operating agreement doesn't bind element, this notion that the management services agreement, overrode the arbitration clauses. I think Mr. May eloquently articulated why those arguments don't hold water. We certainly set it out in our briefs. So when those fall away, what's left? What's left is the district court is essentially saying, I have leave under the receivership order, and because I can give or deny leave, I'm going to deny leave. And that's, if we're going to apply abuse of discretion standard, I think that would fit and meet the definition of arbitrary. And as Mr. May pointed out, if we are going to rely on those other two legal bases, those are erroneous legal conclusions and inherently an abuse of discretion. So I'll close by saying, even if we get to the rubric where we're looking at, does the court have the right to deny or grant leave, and it's abuse of discretion, I think there has been an abuse of discretion. And one last interesting point that came to me when I wasn't there, the transcript of the district court, one of the counsel for the receiver actually sort of attempted to urge the district court into saying on the record, are you denying leave? And what the district court said was, no, I'm denying a motion to compel arbitration. So at least the district court didn't believe it was operating under that sort of standard. And so I really do think we are in a de novo review. Thank you, Your Honor, so much for your time.
Okay, thank you. We'll give you a little time for rebuttal. Sweet.
Good morning, Your Honors. May it please the court. So, I think everyone agrees that under Kansas law, the court has to determine if an agreement to arbitrate exists in the first instance. The de novo review discussions all have to do with if there's an agreement to arbitrate, how is it interpreted. But in this instance, this court faced with multiple and inconsistent agreements. The 4 that were cited by counsel, as well as 3 or 4 others prior to 2020.
And there are a few in the record, in the limited record we have, that do not speak to arbitration.
Absolutely. In fact, at the same time the operating agreement was executed, other contracts were executed, some with arbitration agreements, some without arbitration agreements. So there's no clear expression of the parties as to what the intent is back at that time. But even rolling forward, there's the amendment to the operating agreement, which does have the boilerplate general language that everything else is affirmed that we're not amending, but doesn't speak to arbitration. But then with an effective date of a week or 2 later in time, the management services agreement is very explicit and says all matters, all disputes will be heard in Sedgwick County. So that happened. That was the last contract between the various parties to this appeal. Then fast forward 2 years later, and you've got a receivership, and you've got, as was noted by counsel, in a negotiated receivership order that was negotiated by Andy, negotiated by Element, negotiated by the lender, presented and argued in front of the court, and agreed to its own process. And the court found, just to make sure we're all clear here, the court found it's not just denial of leave. The court found the receivership order was an agreement by Andy specifically to present all issues to the exclusive jurisdiction of that court. That was part of the court's order. And the court said also the management services agreement is a manifestation of intent to have everything heard by the court. And those two are both the latest manifestation of intent. It's an inherently factual question. That's not a de novo question. The court had available to it a great deal of briefing on that, a great deal of argument, and that court happened to be the court overseeing the receivership.
So let's ask just some real practical things here. Evidence is put into the record either by the introduction of exhibits or through testimony, not through arguments submitted in briefs or submitted orally. So when we talk about fact questions, what facts do we really have in the record other than the agreements we don't even have the receivership, but it sounds like we can take judicial notice. We have those, and we have the judge's ruling, basically. Those are the only real evidentiary things we have in the record, aren't they?
It was not an evidentiary hearing in that evidence was offered. The judge did not take the evidence.
Right, so, but
But-
we're, as you know, a court of record. We can only go with what's in the record, and the greatest arguments in the world may be presented below, but they're not worth the paper they're written on.
But the papers themselves are evidence, that facts the court can consider when making.
But those, that it would be de novo. Actual reading of a written instrument is pretty clearly de novo. Where it seems like the discretion comes into play is whether or not the district court wants to grant leave in order to require arbitration. And something tells me that if the judge would have granted leave, we probably would still be here. We just would have had different colors on the briefs.
Potentially, I mean, that's obviously a situation we're not in, but the procedure and process through which motions like this are.
But what can we consider? What's really in this record being so early and no evidentiary hearing? Don't we really just have the agreements and the judge's ruling?
Well, the judge had available to it the facts that it had, that.
We might, but if it's de novo, you know, bless the judge's heart. You guys get do-overs here. So what I'm trying to find out is what evidence is really in this record for us to look at other than the agreements themselves, which we are in good a position to read and interpret as the district court.
Well, first, the evidence provided, the documents and exhibits, historical record available to the court at the time was evidence available to that court.
And that was admitted into evidence,
It was
and I'd
not-
have to look back.
It was not formally handled as an
So it
evidentiary
was
hearing,
a proffer?
but none of these would have been handled, none of these types of proceedings, it's rare these types of proceedings are handled if a true cross-examination of witnesses.
Well, if I was
presenting
doing this at the
factual
district
evidence.
court level, I probably would have had you mark your exhibits, and hopefully you would have stipulated to the admission, or even a joint exhibit notebook. So it is often done, maybe not anymore, but that's what used to be done. But what you're telling me is there was nothing admitted into evidence.
There was no-
There was proffers made, to cut to the chase.
Yeah, there was no formal request for admission. It was all
So
presented to
should
the
we
judge.
be looking at this other stuff, or should we just focus on what actually is in the record and take judicial notice of the receivership?
Well, if these contracts are admitted and considered evidence, then all of the record is evidence, because the contracts are not formally admitted either. There was no process where an arbitration agreement was ever admitted into evidence. So if you're not going to consider any of the evidence that we're citing to in considering whether the court made a fact determination and the dueling standard applies, you can't admit the contracts either.
But we could admit the operating agreement, which I think everybody agrees that certainly at least the members are bound to regardless of whether they signed it or not.
Well, the operating agreement exists, but it was never offered into evidence.
But it's the basis of your claim.
No, it is a basis cited for certain fiduciary
Right,
duty
so it's in the
questions.
petition.
It's discussed in petition.
Right, it's specifically cited. We talked about that in Mr. Geiger's argument. It's specifically cited. The breach of fiduciary duty, part of the duties that are being alleged arise out of that
Well, they're
operating
common-
agreement.
They're common law duties that are also stated in the
Right.
operating agreement.
So that operating agreement seems like that's fair game. It's part of the petition. It's part of the claim. Maybe all these other agreements aren't. The receivership, it sounds like both parties want us to take judicial notice.
Well, and I think the management services agreement, everyone agrees that was in.
It sounds like everybody agrees on that one.
Yeah, everyone agrees the receivership order.
But what I'm trying to find out, is there anything out there that you think we need to be considering?
Well, the briefing was fairly extensive on this issue, and I think anything in that briefing was accepted by the court into, not formally, but accepted into evidence and considered by the court, including the attachments to it.
And you would agree that any order that we have, which is somewhat unique here because it's basically a bench ruling, and of course on the bench we think out loud, and then all we have then is a journal entry incorporating the bench ruling, but everybody's bound by whatever the district court said on that bench ruling.
Yes. Yeah, and of course, the court has in front of it its own history in that case and knowledge of the facts that it can rely upon and consider, which it did. It, in fact, spoke to the fact that the receivership order was agreed to by Andy and by Element, the parties to the receivership order. It had those facts available to it. So all of that it relied upon in determining what the final and most recent iteration of the parties' agreement is with regard to dispute resolution, and it found the receivership order was, and if not the receivership order, the management service agreement was, and that for those reasons, it determined that there was a negative factual finding. There was no, the Andersons had not carried their burden, their summary judgment-like burden, to establish there was an agreement to arbitrate the disputes there in front of the court. And that is itself is a failure of the Andersons to prove their case at that time. So when they come here, it's not the standard of de novo, what does this contract say, does it mean arbitration? It is their failure to prove to the court that there was an agreement to arbitrate the claims that are currently being debated here. And so therefore, the dueling standard applies to all of it. And our position on that is that the court made that determination, found, we believe correctly, but it's not our burden to prove that, found that the agreement of the parties in the receivership order was that the court would be handling everything. There was the absent leave because it was a fairly broad order, but in that instance, this was a party to that agreement that agreed everything would be handled in court. And alternatively, the management services agreement, which had similar language that all disputes between the parties would be handled.
Now, a distinction between this case and the case we heard earlier, and there are other distinctions, but it seems like from our perspective, the primary distinction may be that in the first case, the managers were not parties to the receivership, at least were not directly parties to the receivership. Here, the appellants are parties to the receivership. Does that make any difference in our analysis?
It should not make any difference as to her decision that the latest manifestation was not the operating agreement, it was in fact the receivership order, which would obviate the operating agreement. It's the same thing, management service agreement would obviate the operating agreement. As far as the issues of managers and those standards, there may be some slight differences there, but if you affirm the decision in our case that you're not going to disturb the court's factual findings and decisions under the dueling standard, then that should obviate the issues in the other.
And this was presented before the district court as a complete package. These two cases were
They were, I think.
argued together, it looks
was
like.
jointly argued the same day for efficiency. And because, just similar today, because of so many overlapping arguments, it was all presented in the same, I think there's a singular transcript for both matters. I do want to address, because the court had asked about it to others. One thing to note under 6D, there's all this discussion, they try to make a lot of hay with third-party question. But note, and in that same sentence, they're specifically exempting from this the security interests of the plaintiffs and Andersons with regard to other agreements. And Andersons can't say that language is irrelevant here, because if the Andersons are specifically excluded from the things the receiver has the ability to not be bound by, but then there's specific language the receiver is bound by, that kind of clarifies a bit that the third parties is not some get-out-of-jail-free card for the Andersons on that one. And I think it's already been covered, but under 15B1, which really is the operative part for the agreement of the parties for Sedgwick County District Court jurisdiction over their claims, I think the language is pretty clear there that Anderson's is a party that would have to seek leave, or it has subjected itself to the jurisdiction. It hasn't really been addressed today, but I would say the definition of commencing, prosecuting, continuing, and enforcing in any form other than this court is stretched pretty far in the appellant's argument here. I think there's no question that seeking to to move a proceeding that's ongoing into an arbitration process is, would be certainly fit under that definition, so it's certainly something. And again, it's been discussed, but even if the court does not affirm the decision that the receivership order was the latest iteration of the party's intent with regard to arbitration, that's not the abuse of discretion standard, that's the dueling standard, the deferential standard. But even if that's not, is not found, it is an abuse of discretion standard, and in this circumstance, given that the Andersons was a party to this, and the Andersons had been proceeding under this exact agreement for 2 years by the time this came up, I think there's a great deal that the judge could rely upon to exercise discretion to deny their request for leave to proceed in another proceeding. And again, I'm happy to answer any questions. I think you've heard a great deal in both of these proceedings. I think in this instance, the court's decision as to the last manifestation of intent of the parties should not be disturbed. I think there's, it is not, it meets the deferential standard, and this matter should be remanded for further proceedings. So, thank you.
Okay, thank you, counsel. Mr. Davis, I'll give you a couple minutes here to wrap this up.
Thank you so much, Your Honor.
You're welcome.
I want to try to be clear about what happened in the district court. As Your Honors noted, no witnesses took the stand. There weren't exhibits offered into evidence. The case was decided by the district court based on the undisputed terms of written contracts that both sides agreed could be submitted to the court by way of briefing. As Your Honors have mentioned today, this court is just as capable as the district court of reading these written.
We didn't say we're just as capable. We
Well-
have we have the authority. That doesn't mean we're just as capable, but we like to think we are, and we thank you for that.
That's fair point, Your Honors, and I, certainly didn't mean to discount the district court's, commendable prowess. But my point simply is this is de novo review in terms of Your Honors deciding what these written instruments mean and how they interact.
Seems like we've kind of got a mixed standard of review a little bit here. I mean, it seems like there's some things that are abuse of discretion, and then when we're interpreting the face of the contracts, then it's de novo or matter of law.
Well, in our view, the only way, in our view, that abuse of discretion might come into play is if Your Honors are looking at the introductory language to 15B about whether or not to grant leave to do certain things that are purported.
Well, don't you think we should at least look at it for just to do our job? Shouldn't we look at it at least?
For sure, but that raises kind of the main point.
But even then, I think it ends up ultimately becoming an interpretation of what that means, and then whether the district court abused or didn't abuse its discretion.
Precisely, Judge, and I just want to, I was looking through the record on appeal, and I want to close with this. This is transcript volume 7, page 54. The court's ruling was, quote, "The other arbitration agreement, I believe, were overruled essentially by the management services agreement, but most definitely by the agreed receivership order, which the parties negotiated and signed and then the court filed, agreed to because it was agreeable to everybody." On the very next page, the receiver's counsel attempted to get the district court to frame its ruling as denying leave, and the court said, "No, I'm denying the motion to compel." And I think that's important because it shows the court's decision below was an interpretation of the receivership order overruling the arbitration clauses. And if you look at this receivership order, just in a general sense, it doesn't mention the word arbitration anywhere. Certainly by April 2023, arbitration was so ubiquitous, and with sophisticated counsel, if they intended to prohibit arbitration, the order would have simply said that. And then when you lay the Federal Arbitration Act on top of it, right, in terms of resolving doubts in favor of arbitration, and frankly, the entire, hour-long process here this morning, which I've enjoyed tremendously, the notion that we're having these vigorous debates about what the receivership order means and does it prohibit arbitration, at best, there's doubt. And the Federal Arbitration Act says that doubt needs to be resolved in favor of arbitration. Thank you for your time today, Your Honors.
Well, thank you all. Good arguments, and we will take this under advisement and get an opinion out to you as soon as we can. If everybody wants to change places, feel free. Well, since we're just to the guest, I do not know.
Do you need a trash can?
Oh, they're right there.
Here we
I
go.
see it right there.
Okay, I've got one here too. Mhm. Thank you.
Yeah. While we're waiting, does anyone want to talk about arbitration? Yeah.
Do you feel lonely that everybody left?
Yeah, deserted.
You ready? You ready? Okay, we'll go ahead and call case number 127215, State of Kansas versus Rainey. Will you please state your appearances for the record?
Good morning, Your Honors. Emily Brandt, Appellate Defender Office, here on behalf of William Rainey. May I please request 3 minutes for rebuttal this morning?
You said 3?
Yes, please. Thank you.
12 and 3. Okay.
And may it please the court, Christiane, Assistant District Attorney, appears on behalf of the state.
Ms. Brandt, whenever you're ready, you can begin.
Good morning, Your Honors. Again, Emily Brandt on behalf of William Rainey. We're here this morning to discuss a Terry stop and frisk. I won't go into the facts because I know Your Honors have read the briefing, but I will say if this court finds that there was no reasonable articulable suspicion to support the stop, then this court doesn't need to reach the question of whether or not there was reasonable articulable suspicion to support the frisk. But today, Mr. Rainey challenges both. I'll start by saying that I think that it has long been the law in not just Kansas, but in the United States, that presence in a high crime area alone cannot support reasonable suspicion for a stop. And I believe that that is exactly what has happened here. And if this court affirms the district court's ruling, then you will essentially be rendering busy apartment complexes Fourth Amendment free zones. Mr. Rainey was simply at an apartment complex here in Wichita late one evening in January, and he appeared to maybe just be standing, maybe just be loitering, maybe knocking on an apartment complex door based on the testimony, when law enforcement officers just pulled into the
Well,
apartment.
let me ask you this then. If he was loitering, does that mean he's trespassing? That would give the officers the opportunity to look?
No, Your Honor, I don't believe that loitering and trespassing are the same thing. I mean, sometimes I loiter in my work parking lot, right? I might be talking.
But you have permission to be there. There was a no trespassing sign on this property as I read the record. Is that correct?
I believe that based on the record, there were signs about no trespassing, but there's nothing in the record to suggest that Mr. Rainey was told that he could not be at that apartment complex. There's nothing in the record that says that Mr. Rainey couldn't be there. And so loitering alone does not mean that you're trespassing. To be trespassing, you must be on land that you have been told you cannot be on, and that there are signs posted that you cannot be there. This idea that an apartment, again, I think that this just goes back to the idea of this being sort of like a high crime area in Wichita. The idea that any apartment complex owner can just sign a blanket trespass affidavit and put up signs And that gives police officers carte blanche to talk to anybody at an apartment complex, simply cannot withstand Fourth Amendment scrutiny.
Well, here, I mean, it seems like the officers knew that this was an issue at this apartment complex. They drive by, they see somebody standing there, and as they pull in, the guy goes to a door and acts like he's knocking on it, or he is knocking on it. Isn't that correct? I mean, he changed his position when he apparently saw the officers coming, correct?
Well, Your Honor, so did the officers. We have conflicting officer testimony. I mean, everything Officer Jameson says is that Mr. Rainey didn't go knock on the apartment complex door until they pulled into the parking complex. But Officer Houston testified that William Rainey was knocking on the apartment door to apartment 16.
So we're looking for substantial evidence here.
Right.
And so we're not going to balance those. We're going to go with the one that supports the party with the burden of proof, correct?
Correct, Your Honor. And so I suppose that, but again, what does it matter if within a matter of seconds, Mr. Rainey goes from being maybe near his vehicle to then knocking on an apartment complex door? I think that that is just what you do when you go to an apartment complex. You are there to knock on a door or to see somebody. And again, the officers need reasonable articulable suspicion about William Rainey. It cannot be that just anybody at an apartment, anybody standing in an apartment complex that looks like maybe they're not knocking on a door. They don't know who the tenants of that apartment complex are. They don't know who the social guest of that apartment complex is. There's no reality where they had any articulable suspicion about what William Rainey was doing there.
Well, you don't think they had a reasonable suspicion? You know, it's more than a hunch, but it's not very much, correct?
Correct.
And so all they need is reasonable suspicion he was violating any ordinance or state law, correct?
Correct.
Okay, so the criminal trespass ordinance for Wichita says criminal trespass is entering or remaining on any land by a person who knows he's not authorized or privileged to do so. And it doesn't say anything about direct knowledge. I mean, they know. It doesn't mean that anybody particular had to tell them so. And such premises or property are posted in a manner reasonably likely to come to the attention of intruders. So our no trespassing sign meets that second requirement. Would you
Sure.
agree?
Yes.
Okay. So officers are never going to know if a person knows they're not authorized or privileged to remain there. But they can suspect by virtue of the fact it's posted no trespassing, and they know this place has a problem with high crime or loitering, and this guy is standing there when they see him, and he changes his position when they come in.
Your
That
Honor-
doesn't seem like a reasonable suspicion to you?
Your Honor, no, I have to respectfully disagree. I think that is the case. Again, you render apartment complexes Fourth Amendment free zones. I think that this is sort of like State v. Sanders, which is cited in my reply brief, where officers say they see somebody who's maybe fidgeting with a car door, and so they pull them over suspecting that maybe they're committing some sort of act of burglary. And the Kansas Supreme Court says, well, no, I mean, you're in a parking lot, it's between a restaurant and an apartment complex. Officers have no reasonable articulable suspicion that that's not the car of that person. I just think that that is not reasonable articulable suspicion that William Rainey is trespassing at what has been admittedly talked about as a busy apartment complex, and specifically apartment 16 that Mr. Rainey knocked on. Officers knew to have a large amount of traffic in and out. So no, I think that again, this like blanket idea of this trespass affidavit or signs is just a way to make this apartment complex a Fourth Amendment free zone. Officers are allowed to stop whoever they just see.
Well,
I just don't think that can survive Fourth Amendment scrutiny.
Do large apartment complexes normally have a no trespassing sign?
Your Honor, I could not speak to that. I don't know.
I
All
don't
I
either.
know.
I mean, I'm just curious. This is called a high crime area. I don't really know what the definition of that is. Do you?
Your Honor, I don't, but I do know that high crime areas are not a reason to stop people. And you can see in the district court's ruling, he knows that. He straight up says that it's not supported by case law, but when he thinks about it, he thinks it's incumbent upon police officers to do an investigation when they see someone in a high crime area where maybe there's acts of trespassing.
So you would say the fact there was a trespassing affidavit on file and the officers knew that is really immaterial?
I think it is immaterial. I think that, again, it gives the officers the ability to enforce whatever, should they actually come across a trespasser. But I don't think those things alone are enough to amount to reasonable articulable suspicion that every person at that apartment complex can be stopped for trespassing, particularly here where nobody cited William Rainey for trespassing. William Rainey wasn't booked on trespassing. This seems quite pretextual to stop William Rainey and anyone else that they see at this apartment complex.
Let's assume that there was reasonable articulable suspicion under this city ordinance to at least inquire. Seems like you also have an argument you'd want to make about, could they pat him down? You might move to that argument just as well.
Yeah, correct, Your Honor. So, yeah, if this court finds that there was reasonable articulable suspicion for the stop, which I won't concede there was, then there was not reasonable articulable suspicion for the frisk, which requires a different sort of reasonable articulable suspicion that Mr. Rainey posed some sort of threat or public safety risk to the officers, which he just very clearly did not. Again, it's a cold night in January. Mr. Rainey is not wearing gloves. I'm sure that all three of you have watched the body camera footage. His hands are in his pockets when the police walk up to him. There's no sound at this point, but they motion at his pockets. He takes his hands out. Officers tell him, don't put your hands in your pockets because I don't know what's in them. They ask Mr. Rainey a question. He points back to apartment complex 16. He comes back. He moves to put his hands in his pockets. He stops himself and puts his hands over his chest. And the officer just goes, I don't know you, so I don't know what's in your pockets. I got to pat you down. And pats him down. There was no reasonable articulable suspicion that Mr. Rainey was armed and dangerous that was articulated by the officers. In fact, the officers said that this was just sort of a standard of officer safety, which again, under United States Supreme Court jurisprudence, cannot stand.
Didn't the officer or one of them also testify that his continued movements toward his pockets made them question their safety?
Well, I would, one, push back. Again, I know that we're looking at evidence in light most favorable to the party with the burden, but here we literally have body camera footage of what happened, which I think is contradictory to Officer Jameson's testimony. He did not continually try to put his hands in his pockets. He tried to put his hands in his pockets one time and folded his hands over his chest. And so within a matter of 15 seconds, where Mr. Rainey is complying with a lawful order, the officer goes to pat him down. So I do not think that it's a fair comment on the evidence that he's like nervously trying to put his hands in his pocket several times.
Are you trying to have us make a credibility ruling then?
I mean, I think that you can. Again, the facts have to be based on substantial competent evidence, and the best evidence is the body camera footage. We can all watch what Mr. Rainey does in response to what Officer Jameson orders him to do. And even if Mr. Rainey did several times try to put his hands in his pockets nervously, which he didn't, based on body camera footage that we can all see with our eyes, that nervousness does not amount to reasonable suspicion that he's armed and dangerous. The court has said that in State v. Dean. Again, there needs to be reasonable articulable suspicion that William Rainey is armed and dangerous, and nervousness alone cannot amount to reasonable articulable suspicion.
So just back to a kind of basic question about this ordinance, could the officers, even before he put his hands in his pockets to warm him up or whatever, could the officers have went ahead and placed him under arrest under that city ordinance?
Well, Your Honor, I don't think so, because I don't think they had reasonable articulable suspicion that he was committing the crime of trespass. Again,
Well, but I, and correct me if I'm wrong, I thought in response to Judge Garner's question that you said that those elements at least had been met, that he's on the land, he's not authorized to be there, and the property is posted.
No, because again, it requires some level of knowledge, and there's no evidence here that Mr. Rainey knew that there were these signs posted. I don't believe that Mr. Rainey was under any knowledge that he could not be at that apartment complex. And again, it does appear he was a social guest of apartment 16. I know that it happened after the search already occurred, after the frisk occurred, but the older Hispanic gentleman who lived in apartment 16, although he initially didn't recognize William Rainey, said that he did recognize Mr. Rainey. So again, I don't believe that there was, I don't concede that they could have arrested him for trespassing, because then I would have to concede that there was reasonable suspicion that he was committing that crime. I don't believe that exists here.
Well, you anticipated what my next question would have been.
Well, how about his the officer's observation of his inconsistent statements, that he was there to see a woman at room 16, and then changed it to be a Hispanic male.
Well, Your Honor, I guess I don't know exactly what to make of those inconsistent statements, except that all the officers testified that apartment 16 is a very busy apartment. I don't know why, just because an older Hispanic male is on the lease, doesn't mean that a woman doesn't also live there, or that a woman wasn't there the last time Mr. Rainey was there. So I don't think that those inconsistent statements amount to anything. And to the extent that they do, why would it matter? The officers needed reasonable articulable suspicion that Mr. Rainey was committing or about to commit a crime at the time they stopped him. Reasonable articulable suspicion about a crime to support that stop can't manifest based on whatever they tell him when they're interrogating him. That would be for something different, right? Like we might be talking about, you know, an arrest for trespassing or something like that. But to stop somebody, officers needed reasonable articulable suspicion that he was committing a crime. And they didn't have that at the time they pulled into the apartment complex to stop him.
You're a little bit over 13 minutes. If you want to save a couple minutes for rebuttal, you might just wrap this part up.
Sure, Your Honors. We would just ask that this court vacate Williams' convictions for possession of methamphetamine and paraphernalia and remand with directions to suppress the evidence that was seized in violation of Mr. Rainey's Fourth Amendment rights.
Thank you. Ms. Allen?
Good morning, and again, may it please the court, Christy Allen on behalf of the state. Yes, we are here on the denial of a motion to suppress. The facts as discussed include that there must be reasonable articulable suspicion, and what we have in this case is we have officers who work this Broadway corridor who testified that it is a high crime area. That definition is not provided in the record, so we don't know what those high crimes are.
So we don't know if it was drug activity, prostitution,
We do
trespassing.
Correct. We do not. We do not. We know that they were classified as high crime. I think Officer Houston classified it as significant crime, but we don't know what those crimes were.
And room number 16, and you know, we've heard so much this morning, just to refresh my recollection, there was some testimony of specifically about room number 16.
Yes, the officers testified that they were well acquainted with the occupant of room 16 because they had, quote, a lot of issues with that unit.
But again, not identified as a drug
No,
officer or
just a
anything.
lot of traffic coming and going is what the officers said.
Just frequent traffic.
Correct. And so what you have is you have officers who have this trespass affidavit. They know that this apartment complex, this specific complex, in contrast to Sanders that opposing counsel cited, this specific complex has had issues with crime. And as they're driving by, they see somebody that they are well aware of and acquainted with the behavior, behaving in a manner that they're familiar with for the crime that they believe is occurring.
Were they acquainted with Mr. Rainey before?
No,
Okay.
they were not, no. And so as they're driving by, they see a person that they observe to be committing the behavior that they're used to seeing for the crime of trespass possibly. So they turn around to contact him. And when they turn around to contact him, he again exhibits behavior that they're accustomed to in that situation. People then, once they see officers, start to walk towards a door. And so all of this for them is it's checking boxes in their mind. This is something that we're used to seeing. And not only that, but he was going to an apartment where they have had issues. And so that gives them the reasonable, articulable suspicion to stop this person. This person exhibiting the behaviors in a high crime area, matching the behaviors that are often observed by those officers.
And for
those
what
crimes.
purpose? To investigate whether this is a criminal trespass?
Correct.
And was this, I'm pretty sure it was, but my notes only said the evening. I assume since this is January, it was dark outside, right?
It did appear, if you watch the video, I believe it appears to be dark, but, and that brings me, well, that gets us to the frisk part, the articulable suspicion for the frisk
Before you
portion.
move on,
Yep.
do you agree then that we shouldn't consider his change of story at all in looking at reasonable suspicion?
I don't believe that the change of story in the reasonable suspicion for the stop. I believe that the change in story goes to the reasonable suspicion as part of the, and And I will be careful, because I think as you watch that video, it's all kind of happening simultaneously. They're having the conversation. So because we have that 30 seconds of silence, there's obviously conversation going there. And so one can only assume that that's when he first said, "I'm coming to see a female." And at that point, he has now provided information inconsistent with the officer's knowledge. The officer's knowledge is, we know a female doesn't live in this apartment. So this again goes to continuing the suspicions. And I will say, when you watch the video, officers pull in, he does not have his hands in his pockets. As he approaches the officer, he bypasses the pockets with the gloves, and he goes to the pants pockets. And there's nothing in the record to suggest that he put his hands in his pockets because it was cold. He never said it was cold. It was January. Sometimes January is very cold in Wichita. I think we had 60 degrees in Wichita this summer, or this winter in January. So that the cold articulation was never in the record. We do not know that for certain. But what this officer explains is,
So is the cold argument statements of counsel?
yes.
All right.
So what we have is approaching the officers, placing his hands not in the jacket pockets with the gloves, but in the pants pockets. He's provided information that is inconsistent with the officer's prior knowledge. He then removes his hands from his pockets at the officer direction that we can assume based on the actions in the video. And what you'll notice is when he goes to place his hands in his pockets that second time, counsel asserts that it's on his own volition that he stops. But if you watch, the officer simultaneously is pointing to his hands at the same time. So it could be, could be simultaneous, but to say that, oh, he realized and he moved it all on his own, possibly. The officer is moving to pointing at his hands. Maybe he's being reminded at that time. But again, it was significant to the officer that he was bypassing the gloves. He was going to the hands in his pants pocket.
So the suspicion is that he may have a weapon, and they just wanted to ensure that he did
Correct.
not have a weapon.
Correct, especially since they have no prior knowledge of this individual. They don't know if he's known to carry a dangerous weapon. And in this high crime area, they determine, we don't know you, we need to make sure that we're safe.
Did they testify about their concern for their safety?
I believe one officer said that he did it for officer safety. And I will draw the distinction on the cases cited by opposing counsel, that of State v. Burton and State v. White. In those cases, you read those cases, and as soon as the officer makes contact, they're patting down the individual. And they say, it's part of my routine, it's just part of what I do. In this case, you don't have the officer immediately going to pat down the individual. He sees the hands in his pockets, tells him to remove it. They're getting the inconsistent story, they're getting the inconsistent information, goes to put his hands in his pockets again, and that's when the officer's like, I'm just gonna pat you down to make sure you don't have anything dangerous. So it is the state's position, Your Honor, that there were particular facts for this specific defendant that gave rise to articulable reasonable suspicion that allowed the stop and the frisk. If there are no further questions, we would just ask that you affirm the district court's decision. Thank you.
Thank you. Ms. Brent?
Your Honors, I'll just be brief. Again, I think that we've heard a lot about how this specific area is a high crime area, about how this specific apartment complex might have issues, etc. I do not believe we've heard anything, and I don't believe the district court heard anything about how William Rainey, at the time police officers stopped him, there was any reasonable articulable suspicion that he, the individual, not he in a specific area, not he in a specific apartment complex, that he, the specific individual, was committing or about to commit any crime. I do not believe there is any reasonable articulable suspicion for the stop in this case, and I believe if this court affirms the district court's ruling, you really are just rendering apartment complexes Fourth Amendment free zones, which the Kansas Supreme Court has said we cannot do. We keep repeating this phrase, high crime area. The district court relied on it being a high crime area. It is very clear under jurisprudence that being in a high crime.
Wait a second, I thought you said earlier the district court didn't make that as a condition of his finding.
No, he did. He said it was incumbent upon police officers in high crime areas to investigate. And he said it's not based on, the district court admitted this is not based on case law, but when I think about it, it's incumbent upon police officers.
So he was looking at the totality of the circumstances.
No, I believe he was making a blanket ruling that if officers are patrolling a high-crime area, they're allowed to investigate people.
And under your view, what would allow a law enforcement officer in this similar situation to investigate an individual in that parking lot for criminal trespass, say?
Your Honors, I guess I don't know because I don't believe Mr. William Rainey exhibited any of those behaviors, so
But you're saying they would need more than what they have. What more would do it in your opinion?
you know, I don't,
Can they never investigate for criminal trespass?
I don't think that's the case, Your Honor, but I certainly don't think that a person just, I mean, loitering just means standing. Loitering means that somebody is standing in an area. The officers don't say that they have observed him perhaps loitering for any extended period of time, or looking into car windows, or maybe knocking on several apartment doors to see if he could get anybody to answer, or jiggling apartment complex door handles to see if maybe they were unlocked and he could get in to do something, etc. There's none of that. They literally just see William Rainey standing at the apartment complex and they stop him. That simply cannot be enough for criminal trespass at a very busy apartment complex. They don't know if Mr. Rainey is an occupant of one of the other apartment buildings, a social guest of somebody there. There's no reasonable articulable suspicion that Mr. Rainey was committing any crimes. And he certainly wasn't arrested for the crime that they allegedly suspected that he was committing. And so I don't think there was any reasonable articulable suspicion for the stop. I also don't think there was any reasonable articulable suspicion for the frisk. I believe that Mr. Rainey was lawfully complying with the officer's orders at the time of the pat-down, and that there was no reason to individually suspect that Mr. Rainey had anything in his pockets, particularly when his hands were not in his pockets. If this court doesn't have any further questions, again, I would ask that this court vacate his convictions and remand for suppression of the evidence. Thank you.
Well, thank you both. It was refreshing to hear about something other than arbitration. Not that we didn't enjoy that, but we needed a little something different, so we appreciate that. As you know, we will take this under advisement and get the opinion out to you as quickly as we can.
Thank you.
Thank you both. So we're in recess till 1:30.
Thank you.
Oh my gosh, I'm so sorry.
And next week we make 8 more units in 8 months.
Good afternoon. Please be seated. Somebody get the door. Well, good afternoon and welcome to the afternoon session of our May docket. We have two cases this afternoon on the docket. I think everyone is experienced and knows, but you have 15 minutes per side for oral argument. If the appellant would like to reserve any of their time for rebuttal, just let me know up front when we state the appearances. So we'll go ahead and call the first case if you want to come forward, which is 128-144, Ebby versus Pistotnik. If you'd state your appearances, please.
May it please the court, Stephen Brave appearing on behalf of the appellant, Bridget Eby, and with your honor's permission, I would request 3 minutes for rebuttal.
Okay, 12 and 3.
Good afternoon, may it please the court, Richard Olmstead appearing on behalf of the defendants, Tony Atterbury, Brad Pistotnik, and Brad Pistotnik Law, PA.
Okay. Well, as I think both of you know, we are provided with a lot of information in advance. So we have read the briefs, pre-hearing memos prepared by our research attorneys, some of the pertinent documents. So the time is yours, but if you want to get straight to some of the legal arguments, so that's fine. Or if you want to advise us of some facts you want us to focus on, that's fine as well. So you may proceed.
Thank you, Your Honor.
You're welcome.
As the court knows from reviewing the pleadings and the underlying court file, this is a case that basically stems around a single issue. Was the plaintiff's expert, Ms. Anna Upinen, qualified to offer the legal opinions that she did? The evidence is undisputed that she is a licensed lawyer, has been for over a decade, has experience as a prosecutor in private practice, done a wide variety of things. The plaintiff's position is clearly under KSA 6456B, her education alone qualifies her as an expert, able to offer an opinion on a legal subject.
How can that be? That would mean everybody who graduates from law school would be qualified as an expert. Is that your position?
It is, and I would submit to the court, authority for that isn't in any Kansas case that addresses lawyers. But there is a case, Glassman versus Costello, which is 267 Can 509, that held exactly that. In that case, two pathologists offered opinions about a standard of care that applied to an obstetrician, even though the pathologist had never done any obstetric work. The district court struck their testimony. On appeal, the Kansas Supreme Court reversed that and said it was error to exclude the pathologist's opinion testimony, and specifically said it was never intended, that being the statute governing the admissibility of expert testimony, to limit admissibility of opinions by experts who are within the same profession or who hold the same basic licensure. In other words, any doctor can offer an opinion. They are qualified as an expert. Whether it's reliable, whether it was based on sound scientific principles or the rest of the analysis is a separate issue.
So you're saying it goes to the weight, not the admissibility?
Absolutely. I mean, she would get, or she's qualified. I mean, I think that's a given. She's a licensed lawyer with experience. She's dealt with cases involving experts. She knows the statute. She knows that if you have a case that requires an expert, obviously her opinion was you need to consult with an expert, get them on board to successfully pursue the case. Failure to do that in any area of the law is probably going to end up being, a breach of whatever standard of care applies to a reasonably competent attorney in Kansas.
So if the court said no, why didn't you just go hire another expert?
Because my expert deadline had passed. This all happened at the same time we did the summary judgment motion.
But couldn't you ask leave to hire another expert?
No, at this point, I had disclosed my expert, the defense had disclosed theirs, discovery was closed, we were past that.
I understand it's closed, but I've also seen it be reopened.
Yeah, that was not requested. I didn't think there was any possibility that that would occur. Instead, we relied on the defendant's expert, Mr. Finnerty, who also offered the same standard of care opinions that Ms. Yuppinen did. He simply said she didn't, or the defendants didn't breach the duty by not consulting an expert, not designating an expert, and basically abandoning their client. So by the time we got to the summary judgment stage, we had been through pretrial, everything had been done. I mean, I would have had to restart the whole case. And I didn't think there was any possibility that that would ever be granted. This case had gone on for a long time. The expert deadline was long past. The discovery deadline was long past. Everyone had been disposed.
And you never thought there might be an issue with her being an expert in this kind of a case when she'd never done one?
She's never acted as an expert?
Well, I don't think she was ever an expert, and I don't think she'd ever done a personal injury case.
Under the statute, you know, like I said, if someone has the education to know what the law is, and she knows that you need an expert, which was undisputed, and their own expert agreed with her, she's absolutely qualified. The fact that she hadn't done a personal injury case doesn't mean she doesn't have the qualifications to be an expert in the law. And again, that goes back to Glassman v. Costello, and you know, we're dealing with the statute, which is plain. 6456 doesn't say an expert has to have direct experience in the same area that they're offering an opinion on. Simply says you're qualified by any number of ways: experience, education, training, skill, or knowledge. Ms. Yuppinen had tried cases herself where cases involved an expert, understood how that worked, understood discovery deadlines, understood the elements that needed to be proven. How was someone able to work as a prosecutor for close to a decade, do major felonies, off-grid felonies, and is unable to testify about what the standard of care is in a personal injury case? There's no law that says that's what you have to do, and it's clearly contrary to 6456. But if the legislature had wanted that to be the law, we know that they are aware of how to do that. The court only needs to look at KSA 603412, where they did exactly what Your Honor is suggesting. In order to qualify as an expert in a medical malpractice case, you have to spend at least 50% of your time as a physician, not in a subspecialty, just as a physician in general. And again, that goes back to the Glassman v. Costello case.
So that, I'm trying to refresh my recollection on the med mal. It has to be a certain amount of time in clinical practice.
In actual clinical practice, yes, sir. 50% of their time has to be spent actually doing medicine, but it can be in any area. And that's Glassman v. Costello. There's also a case, Whisker versus Hart, which is 244 Can 36. That one says a general practitioner was able to testify about the standard of care applicable to surgeons. Also advise the court as to Tompkins versus Bice, B-I-S-E, 259 Can 39, where that one is kind of an outlier because it involved a dentist who wasn't even licensed by the Kansas Board of Healing Arts being allowed to offer an opinion about oral surgery. That was perfectly fine. Why should a more stringent standard apply to attorneys who don't have a statute like 603412? Well, it does apply to doctors. You end up with kind of a dual standard, and the statute doesn't distinguish between professions. Someone that has the knowledge and experience and education to know what the law is an expert. It was therefore error for the district court to disqualify her from offering any opinion whatsoever. She wasn't even free to testify as to an attorney has a duty to reasonably investigate a case. How is that somehow improper, or she's not qualified to offer that? I think that's something that probably falls within the common knowledge exception. I think everybody knows when an attorney's hired, you need to look into the case. Same way with an expert. If you're a licensed attorney, you've been in practice, and you know that you have a complex issue, such as the diagnosis of an STD, everybody agrees. You've got to get an expert. Not only to testify, but her opinion was you need someone that can guide you through what the applicable medicine is so that you know what to look for as you litigate the case. That applies across the board. Criminal cases, family law cases, tax law cases, you need an expert. The only way to get it in is through an expert. You can't put your client up there and have them testify about what they think the applicable medicine is or what the standard of care is. So,
Now, was the summary judgment, I mean, I know these are interrelated, was the summary judgment based solely on the lack of expert, or was there any other reasons?
my argument is yes. Once Ms. Upinen was disqualified as an expert, the whole case went away. I mean, that undercut everything because we didn't have the necessary opinion testimony. The district court did make a bunch of additional factual findings. I don't know why those were made or what relevance they had.
Well, part of, you know, we used to deal with Fry, now we deal with Daubert, and some of that's probably gatekeeping type of things. Does that impact the analysis now being under Daubert, that the district court performs a gatekeeping role for experts?
In this particular case, I don't think it does, because no matter how you look at it, the district court was required to apply 6456. The interpretation of a statute is always going to be de novo review. So I don't know that you really get past that, because once he disqualified Ms. Upinen, like I said, everything went away. And kind of the tricky part was, I think kind of getting to the point you're heading to, is if the district court had gone through those additional factors that are in subsection B and said she didn't have sufficient facts, or she didn't, her testimony is a product of unreliable principles. If he had done that analysis, then we would be up here and we would have something to chew on, and I could argue, you know, this is reliable. I mean, what she said was fundamental practice of law, but he never got to that point. And no one's ever said that those three factors in subsection B weren't met by her. And as I mentioned before, their own expert agrees. In this case, the defendants would have known they needed an expert from the jump. They would have known they had the duty to investigate. All those things. There was no dispute over those things. So, I mean, we're asking the court to reverse the lower court's decision on granting Postotnik summary judgment, and on the flip side, Ms. Eby's motion for summary judgment should have been granted. That was properly, when you include Ms. Upinen's opinions, it was properly written, it complied with Rule 141, everything was cited. The response did not comply with Rule 141, had endless objections to things that had been admitted in the defendant's answer. Things that had been fundamental and long well known, they objected and simply didn't respond to it. So we're asking the court to reverse the decision granting the defendant summary judgment, and also reverse the decision denying Ms. Eby's motion for partial summary judgment on the existence of a duty to exercise reasonable care, as well as the KCPA claims.
So let me ask, from your briefs, it seemed to me that you were conceding that if we affirm the expert's disqualification, then summary judgment was properly granted. Is that correct?
Yeah, I think, you know, Mr. Finnerty did agree on a lot of the standard of care, but the causation element only came from Ms. Upinen. So yeah, if you disqualify her, then suppose arguably you could have the causation issue go to the jury, because that's normally a fact question. But here I think it would have to be supported by an expert opinion.
Thank you.
Thank you.
Thank you.
You may proceed.
Good afternoon, and may it please the court. I intend my comments today to be brief and address only 3 issues. Of course, if the panel has additional questions for me on the issues that were raised in our brief that are not addressed today, I'd be happy to answer those. The first of those, I will briefly address the standard of review applicable to the decision to disqualify Ms. Upinen. Mr. Brave, during his remarks, indicated that the standard of review was de novo because a statute was reviewed. There was no statute reviewed. The Kansas Supreme Court in State v. Aguirre 313 Can 189, addressed this exact issue and said that both when assessing how the district court performs its gatekeeping role and whether or not to allow in expert evidence, we apply an abuse of discretion standard.
So in a way, it sounds to me like it's somewhat of a mixed standard review to the extent of certainly the statute controls what an expert's general qualifications are, but then we apply Daubert to see whether it's reliable underneath the statute.
If you get to that second phase,
Okay.
this case was decided at that first step.
Okay.
And what the panel of this court in Smart versus Burlington Northern Santa Fe said, and this was adopted by the court in Aguirre, is says that to determine whether the court adequately performs its gatekeeping role, we look to decide whether the expert is qualified. The court must look to decide whether the expert is qualified by knowledge, skill, experience, training, or education to render an opinion. And that is precisely what the district court did in this case. It considered the briefs of the parties. It ordered a KSA 6, or it didn't order, it held a KSA 6247 hearing and heard arguments of the parties. Ms. Yumpinen was not called to testify at that hearing, and then it issued an opinion based on the evidence presented.
Well, why wouldn't your opponent's position be correct? That if you've gone to law school, you're an expert in the law, you've got 10 or more years of practice, of prosecutor and other things, why isn't that sufficient to speak to a basic standard duty of care for an attorney?
A couple of reasons, and I'll start with the most obvious, and that's because the Kansas Supreme Court has told us that it doesn't work that way. Starting in 1984 with Bowman versus Doherty, the court held, quote, "The duty of an attorney to exercise reasonable and ordinary care and discretion remains the same for all attorneys. But what constitutes negligence in a particular situation is judged by the professional standards of the particular area of law in which the practitioner is involved." After Daubert, which was decided in 1993, we have multiple cases from both this court and the Kansas Supreme Court citing that specific provision of Bowman versus Doherty with approval. The first of those was Zimmerman versus Brown, which is a Kansas Court of Appeals decision. Then Bergstrom versus Noah, 266 Can 847. The Supreme Court cited Bowman, once again, in affirming the holding at the district court level that disqualified the plaintiff's attorney because of his, quote, "lack of expertise in the area of antitrust law in the Kansas statutory law upon which," end quote, "the plaintiff's lawyer proceeded in the underlying litigation." And then finally, this court, in an unpublished decision, which is cited in our briefs, the law office of Ross D. Alexander versus Brown, applied that same reasoning. In that case, Mr. Brown was a licensed Kansas attorney. He was going through a divorce and hired Mr. Alexander to represent him. During the course of the divorce, there was a dispute that arose over fees. Mr. Brown ended up suing Mr. Alexander for malpractice, and the court disqualified Mr. Brown and held that even though he is a licensed Kansas attorney, because he had no experience in domestic cases, he was not qualified to be an expert on the standard of care in a domestic case.
So do we really have a different standard for expert attorneys as lawyers as compared to expert attorneys in medical malpractice cases?
Well, in medical malpractice, it's a little different because there's a separate statute that applies, 643102. So there's a little different standard in medical malpractice that doesn't apply in this case. But the standard for lawyers is clear according to the Supreme Court. And it's not just Kansas authority. Authority from all over the country holds the same thing. I cited several of those in our brief. I think the most notable that I'd ask the panel to consider is Butler versus First Acceptance Insurance Corporation, which is a Georgia case, Georgia federal case, out of 652 F sub 2nd 1264. And in that case, an incredibly experienced attorney, 30-plus years of litigation experience in personal injury cases, the co-author of the Georgia Handbook on Litigating Personal Injury Cases, was found to be disqualified in a tortious failure to settle case because he lacked experience in that area. The court applied the exact same reasoning that the district court in our case applied and held that the witness wasn't qualified. But here, it wasn't just Ms. Yumpinen's lack of experience, any relevant experience, that rendered her unqualified to present an expert opinion. It was also her lack of education that provided the specialized knowledge necessary to be an expert under KSA 6456. I asked Ms. Yumpinen about her legal education and what she remembered about it to find out how her legal education supported or informed the opinions that she offered. And the only testimony she could give me is that the only thing she remembered about her law school education was that she wanted to get out of there in a hurry.
Well, I think we can all agree with
Yeah,
that.
join the club.
I graduated 42 years ago today.
Today.
So.
We asked about authority, legal authority upon which Ms. Yumpinen arrived or relied upon to reach her opinions. She could identify none. She said that she had to learn the law.
Say that again.
She identified none.
No legal authority. that
No
she
legal
relied on.
authority. None.
Thank
Asked her, excuse me, I got sidetracked. She couldn't identify legal authority. We asked her to explain how her experience counseled her opinions. She couldn't explain that. Plaintiff has the burden to prove that her expert is qualified. When it comes to her education, there is nothing in the record for the panel to base its decision on. There's no transcript. There's no testimony about what courses she took in law school, how she performed in law school. The fact that she passed the bar doesn't necessarily make her an expert on civil litigation. We don't know what questions were asked on the bar that year. There's zero evidentiary record that would say what Ms. Yumpinen's education was, and from her own testimony, she certainly doesn't remember it.
Would you say that somebody who's been to law school is, in the eyes of the public, maybe an expert in the law, but that's not what the statute requires?
I think I would agree with that, and anyone that holds a law license would know that every family member they have calls them and thinks that they should know everything about the law. But I think we also have that shared experience where we, who are humble enough to admit it, will say, that's an area of law I don't practice in, and it would be foolish for me to venture into that area and offer an opinion. That foolishness is why we're here today. The question is, did the district court abuse its discretion when it found Ms. Yumpinen unqualified? And the answer to that should clearly be no.
Well, how do you respond to the argument that Mr. Brave made that, yeah, these are, he didn't say this part, but these are good arguments you're making, but basically that goes to the weight to be given this expert and not the admissibility, that she should be allowed still to testify, and then you can challenge, undercut her qualifications at will.
Well, one, I think that runs counter to the authority that I've discussed today and that's cited in our opinion, or in our brief, excuse me. And two, I don't think the law should be, so long as somebody is brazen enough to offer a foolish opinion that they're not qualified to offer, we should go to trial. My client shouldn't have to suffer the expenses and time and frustrations of a trial simply because of the argument that, hey, you can prove that she doesn't know what she's talking about at trial. We proved that she didn't know what she was talking about in her deposition and in our briefing. And then the last issue, Your Honor, is I don't think it matters. And that's because even if she were found unqualified, there is no evidence of proximate cause.
You mean even if she were found qualified?
Qualified, excuse me.
Okay, thank you.
And her opinions allowed. And that's because the three proximate cause opinions that she offered are all barred by collateral estoppel, the law of the case, or Ms. Eby's prior sworn testimony.
Well, law of the case changes as the case goes along unless you have an appellate decision that sends it back. So what do you mean by law of the case
It is
here?
the prior appellate decision in this case.
You are referring to that. Okay, got it.
Yes,
Got
I
it.
am referring to the prior decision of this panel, and I'll address each of those three opinions. The first opinion Ms. Yumpinen offered on causation is that Ms. Eby relied on negligent advice from Mr. Atterbury in choosing to settle the underlying litigation. But Ms. Eby has repeatedly testified under an oath that she didn't even think she was settling the case when she signed the settlement agreement. And we've provided in our brief multiple citations to the record from the underlying case and from this case, where she has confirmed that that is in fact her testimony. In the prior appeal, EB argued the exact same thing. We relied on bad advice. It was the bad advice that's the negligence, and that's where our harm lies. And this is what the court said in that appeal. In the prior appeal, she argued that she did not simply up and decide to settle. Instead, her decision was based on legal advice and counsel provided to her by the defendants. The problem with this strategy is that her legal arguments in the summary judgment pleadings and on appeal are contrary to her own testimony. She cannot advance a legal argument to avoid the application of collateral estoppel that is contradicted by her own testimony. And that was at page 5 of that unreported opinion. The next opinion that Ms. Yumpinen offered on proximate cause was that Ms. Eby lost her ability to proceed to verdict in the underlying litigation because the defendants did not make sure she clearly understood the settlement agreement that was being signed. That too is foreclosed by a different decision of this court. In BE versus GG, and that's an unreported case, 2018 Westlaw 4167678, the court held as its finding, Ms. Eby understood the agreement and knowingly agreed to mutually dismiss all pending claims. As a result, she's collaterally estopped from advancing that opinion for Ms. Yumpinen. And then finally, Ms. Yumpinen's proximate cause opinion was that Mr. Atterbury somehow entered into the settlement agreement without her knowledge or consent. This also is foreclosed by this court's prior opinion in this case, where the court held Ms. Eby is collaterally estopped from arguing that she was harmed because her counsel verbally agreed to dismiss the prior lawsuit without her approval. And that's at page 12 of that unreported opinion. Therefore, even if she hadn't been disqualified, all of the causation opinions that she offered are barred. They're inadmissible, and therefore there was no evidence at summary judgment that the court could have looked to deny the defendant's motion for summary judgment. Summary judgment must have been granted based on the absence of any evidence of that essential element of her claims, the proximate cause element. Unless there are further questions, I have nothing else.
Well, I do have one question, and that is, what are we to do with the Kansas Consumer Protection Act?
That decision rises and falls with the malpractice decision. And again, we can go back to the court's prior decision in this case.
Okay, well, I just wanted to make sure that we knew what your position was. I mean, I know what's in the brief, but basically it just falls back on the same argument.
Right. This court previously said, on remand, if she's able to establish enough for her malpractice claim to survive, then her KCPA claim survives. But if she is unable to establish that her malpractice claim survives summary judgment, the defendants are free to raise the fact that she is not an aggrieved consumer under the statute, and that's precisely what we did.
Any other questions? Okay, thank you, Counsel.
Thank you.
Mr. Gray, rebuttal?
Thank you, sir. I'd like to start with Mr. Olmsted's reliance on the Butler versus First Assurance case out of Georgia, because that highlights exactly what the issue is. In that case, there was highly esteemed, highly credentialed attorney who offered an opinion, but it wasn't a legal opinion. He offered an opinion about the standard of care that applies to claim adjusters when he had no knowledge of, he'd never been a claim adjuster, hadn't worked for an insurance company, didn't know what that was. He wasn't disqualified as a lawyer expert. He was disqualified as someone able to criticize a claims adjuster in a bad
Settlement of an
faith,
insurance claim.
right, a bad faith claim.
Yeah.
So that's how that came about. And going back to the standard of review, I mean, Mr. Olmsted admitted, and his argument is, unless you have direct experience in a particular subspecialty of law, you cannot possibly offer an expert opinion. That's a de novo standard of review because you have to go back to 6456, and experience is one of 5 factors. You can't just say, we're writing out the other 4 factors, and we're gonna ignore them unless you have direct experience. You have to look at the entire statute. No panel, no Supreme Court decision that I've ever been able to find ever found any part of 6456, either A or B, ambiguous. That somehow requires us to kind of fill in the gaps.
But
It's a-
don't you think that courts commonly require experts to be specialized in a particular area that they're testifying about?
No.
You don't think that this expert statute then is routinely misapplied?
You mean this one that applies to the doctors?
No. Our regular statute 6456.
I think you have to be, you can be a professor, never practiced medicine, never practiced law. I mean, I think you know the basic duties of a lawyer. If she had offered an opinion that was off the wall and didn't have any support in the law, that's a separate issue.
No, I'm just talking about qualifications. I'm not even getting into what her opinion is.
Sure,
I'm
I
just
think-
talking about establishing somebody as an expert witness in a case. Do you think 6455 is commonly misapplied?
No.
Because it seems, in my experience, the judges do require the expert to have specialized experience, training, et cetera, in that area.
But it's just like the Glassman case. If you're a doctor and you have a medical degree, you're free to offer opinions about any specialty. Then you go to the second step. So, I mean, I think that line of cases that addresses the physicians and what they're free to opine upon, I mean, you can take a general practitioner, they can offer an opinion about a neuroradiologist. That is established law from the Supreme Court, and there's no indication that they ever plan to change that. I think all those cases are from the 90s, and they've never been overruled. If you're a doctor, you have the requisite foundation to be an expert. That gets your foot in the door. The second step is usually where, under Daubert, things get trickier, because you have to see if it's a valid opinion, is this completely harebrained? But just merely having the licensure, that's the words used by the Supreme Court in Glassman. The license itself qualifies someone as an expert free to opine upon a medical issue. Same rule should apply to lawyers. Again, if the legislature wanted a different rule to apply, they would have enacted a statute that did whatever they wanted. They haven't done it, so there's no reason to not apply 6456 as written. And we would ask that you afford Ms. Evie the relief she's requesting. Unless there's any further questions, that's all I've got.
Thank you.
Thank you both. We will take this case under advisement to get an opinion out to you as soon as possible. And if you want to come forward, we'll call our last case of the day, which is 128-299, State of Kansas versus Sawyer. If you'll state your appearances.
Meredith Hogan, appearing on behalf of the appellant, Tyler Sawyer.
May it please the court, Assistant District Attorney Matt Maloney for the state.
And Ms. Hogan, would you like to reserve any time for rebuttal?
Yes, Your
How much?
Honor. 3 minutes.
And we have a Hogan case on our docket, so if we get those two confused, forgive us, please. Hopefully no relation.
Probably not. Hopefully.
But you may proceed.
May it please the court. Your Honors, this case is about a man who was battling addiction, and he returned to his childhood home. Despite a lot of issues that he and his mother had had over the years, including his addiction, she had always allowed him to return to his childhood home and had given him offers of help over the years. His defense in this case was based on a simple truth, that he had no memory of being served with a temporary protection from abuse order, so that he didn't understand or know that his mother didn't allow him to be in her house any longer, that she was withdrawing the authority to enter her home or to use her items.
Help me remember, how much longer was it that he was in her home after he actually had it in his backpack?
It was a little bit unclear from the trial testimony from what I remember, but I believe he was living with her in about September of that same year, and then there was an incident on like September 25th, And then she filed for the order of protection on like the 29th of that year, and then this occurred on October 7th. So it had been a very brief period of time.
A week or a few days to a week.
Yeah,
Okay.
a very short period of time, Your Honor. And during that time, after she had filed for the order of protection, she had done things that didn't give Tyler any indication that she had withdrawn authority to enter her home. She had still brought him clothes to his girlfriend's house. She had sent him and his girlfriend, money through some sort of a Cash App means, so that they could purchase groceries. Essentially, he had no indication from her actions that she had withdrawn authority to enter her home, or that she was withdrawing, like, helping him in any way, so that he didn't know that that authority had been withdrawn.
But acts of supporting someone when they're not in your home can't really be equated to inviting someone into their home or saying that she wanted him in her home, correct?
I think that is fair, but up until this time, she had allowed him to come over and to, eat food. She provided for him, because he was her child. And so I think he just didn't understand that he was no longer allowed to do that.
And when were those acts you just mentioned of acts of kindness? Were they after she filed the PFA?
Correct. Yes, that is what the trial transcript indicated, but like the particular dates were unclear, but it was a very brief period of time between those two, the act
But
and the incident.
You're saying taking him clothes meant that she's still giving permission to come into her house?
I'm meaning that it wasn't an indicator that she didn't want him around, because she was going to the house where he was staying temporarily with his girlfriend on occasion. And so she was getting close to him, even though she had filed for this temporary PFA, which indicates, or like a temporary PFA is to prevent him from coming to her, coming around her, coming to her home, anything of that nature. So she was giving him no indications from her actions to show that she didn't want him around anymore.
Except for the PFA.
Yes, but he didn't know about the PFA until.
Well, that's his allegation, right?
Correct, yeah, and that's what his entire trial defense was based on, was his lack of a memory at all of having been served with this. And so he went all the way through trial. His trial counsel presented a defense based on his lack of memory, arguing successfully, I think, or impeaching Officer Johnson's testimony that he had served Tyler with this PFA, or the temporary PFA. And so it wasn't until that very last morning of trial that they found out, sure, he had been given this temporary PFA, but it was while he was incoherent and incapacitated. There was no ability for him to understand what a temporary PFA meant, or like what that officer was saying to him, so that he would understand that that authority had been withdrawn, that he was not supposed to go near his mother anymore.
He didn't get it, he didn't
Sorry.
didn't register with him at the moment he received the PFA.
Correct.
But was it not found in his possessions when he left the jail?
Sure, but there is a difference between physically possessing an item and knowing that it's there. If he was leaving the court or the jail and he was looking through the items and said, "Oh, what's this?" and she said, "That's a temporary PFA. It says you're not supposed to do X, Y, Z," that would give him that knowledge.
Well, he could read, correct?
He could, but he was just released from jail early in the morning with no shoes, maybe no
He had
food.
several days after that,
So this
before
was
this
the
event at
next
his
morning.
mother's. I'm sorry, that was the morning that he went to his mother's or not?
So I'm sorry, I didn't mean to interrupt you.
That's fine.
So he was served with that temporary order on October 7th, which was a Saturday. And then he was in jail, so he didn't have access to that information at all. And then he was released at like sometime later, walked 10 miles, and arrived at his mom's house on the 8th, which is a Sunday, at like 6 a.m. or 6:30 a.m., something like that.
Okay.
So it was a very brief period of time, most of which he was incarcerated. And so in that video footage, it shows that Tyler was incoherent and incapacitated, such that he could not accept service of process for that PFA because he couldn't understand like what it meant. He wasn't
Well,
being
do we
given.
have to understand when somebody comes and serves us with process? Do we have to understand it, or is the obligation of the deputy or whoever served in this case simply to make sure that it's personally served?
So in this case,
Because I may not understand a lot of documents somebody gives me.
I doubt that. But so in this case, the officer said that he specifically went through the document and he would explain to a person who was accepting process.
That sounds above and beyond. I mean, and tell me if I'm wrong, but it seems to me that there's probably a lot of deputies out there that says, you've been served, have a nice day, and they leave, and don't take the time to explain what it is they've just served them with. Sometimes they may not even really know what they're serving with. I assume
the
a
deputy.
PFA they would know. But do they have an obligation to explain?
The statute doesn't state that there's an obligation, but this officer, because it is his standard practice, imposed on himself, I think, a duty to explain it and did as he
So you assumed a
said.
duty.
Correct. And that the purpose of that service of process is to make sure that they understand that they cannot, that there is a viable court order against them preventing their access to this person or preventing them from doing certain things.
I thought that was the purpose of the writing.
Well, yeah, but the service of process with those
Not the
indicators.
service of the personal process to make sure they got the writing.
It's to give them notice of the allegations against them.
So like if we get sued, they don't sit there and read the petition to us. They serve it to us. It shows that you've got it, and then it's your obligation to read
Correct, but I think in this type of case where there are allegations being made against him about conduct that prevents his access to a person that he regularly consorts with, and then he was immediately put into jail where he didn't have access to that document, and while he was being given that document, he wasn't aware of what was happening around him. I think there was an obligation to give it to him at a point in time where he knew that he was being given that document so that he would know to read it later.
Well, let's say it was appropriately served on him, but he didn't know. It still seems like you have, at least your argument here, that there's a Brady violation, that there was some type of body cam footage that was not.
They shouldn't got to the Brady
produced.
yet.
Yeah.
I'm sorry, I couldn't hear that.
I
last
said you
part.
haven't got to the Brady yet.
We're trying to encourage you to get to the Brady.
Oh, my
violation
apologies.
allegation.
Yes, so the whole issue in this case, or the primary issue in this case, is the fact that the state failed to provide exculpatory evidence in this footage showing that Tyler was incapacitated and incoherent when he was given this PFA document, so that he didn't know that it existed. He didn't know what these allegations were. He didn't know what his obligations were under that temporary PFA, stating that he wasn't allowed to go to his mom's house, to be near her, to contact her. He had no idea because he was incapacitated when he was given that information. And then it also meant that he didn't know that he possessed it, so that he needed to review it on his 10-mile walk in the middle of the night. And so
that was rightly or wrongly, that was the basis of his defense. Is that I was incoherent when evidently I got this piece of paper, I don't know when, don't know how, and had they given me this, it would have supported my defense.
So the original basis for his defense, because he didn't remember being served with this at all, and Officer Johnson's, like the service document itself, indicated that Officer Johnson was not even the person who gave it to him, and it was dated on the 10th of October, which was after the incident that occurred here. And so that would have indicated that he wasn't served with that temporary PFA until after the allegations showing that he was unauthorized to enter his mom's house. And so his defense attorney had based her entire argument on he was never actually served. He didn't know that this happened. He wasn't served until the 10th. Officer Johnson, maybe he's remembering something else, I'm not sure. But that his testimony was incorrect, his notes were incorrect.
So- I'm sorry, I didn't mean to interrupt.
Sorry, you're okay.
I have a problem with the Brady claim when it's not in the record. So how can we evaluate your allegation when it's not in the record? The kid body cam. The body cam is not in
I
there to
understand.
support the Brady claim.
I figured that would be a question that would come up today. And so I think the court should take the stance that was taken in Newsom, which was done by a different panel of this court. And in Newsom, the trial court didn't review the body cam footage at all, which is the same circumstance here. And so in Newsom, the appellate court found that the failure of the trial court to review that footage before ruling on the Brady issue was ultimately an abuse of discretion de facto, because there were no factual findings, or there was no substantial competent evidence to base fact findings on to make that Brady determination. And so that court, even though the footage or the text messages and things were in the record on appeal for that case, the fact that the trial court hadn't reviewed it at all was a determinative factor. And here, the trial court was required to make findings of fact to support its Brady determination. It didn't review any of the footage to have substantial competent evidence to make findings of fact, and that is de facto an abuse of discretion that requires a new trial in this case. Additionally, I think that this court is in a very different posture from the district court in terms of its obligations, because this court has the obligation to defer to the district court's fact findings, but if there are no fact findings to defer to, that's obviously a problem. If the district court had reviewed the footage and made its fact findings, this court would give deference to those and wouldn't, I think, arguably wouldn't even have to review the footage itself. But so the fact that the trial court didn't review this footage at all means that it's unnecessary for this court to do so because it was a de facto abuse of discretion.
And that's by another panel of our court.
Correct, Newsom. It came out in late last year, so the citation on that is 65 Can App 2D at 329. And I can't remember, I think Judge Hill was on that panel and some other judges, but I don't believe it was any of the judges on this panel.
If not, we don't remember. So I want to make something that it's just me that probably doesn't understand this. So Sawyer requests a mistrial, right? And then the judge granted a request to exclude the video. Who requested to exclude the video at that point?
It was an alternative request of defense counsel, so the
Because
state.
why would defense, it seems like defense counsel would want that to come in if the defense is, I'm incoherent, I'm calling my mom by the wrong name, etc.
So the problem is that she had, up until this point, had a defense of he was never served. So to change on the very last witness to a defense of he was served but he was incapacitated, that's really harmful to the entire defense so far. But that request to exclude the evidence, because it was looking like the trial court or it had already denied the mistrial, as an alternative, it was just an alternative kind of temporary remedy. It was not sufficient because, again, there were a lot of other problems in this case that resulted in an unfair trial. But I think ultimately the fact that it was excluded is, oh, sorry.
Well, I'm thinking, what's the duty of the defense attorney to send a request for production for discovery of all the items that the state has?
None. Because this was exculpatory information or impeachment evidence.
Well, we don't know that.
Well, there's Supreme Court precedent saying that the state has an affirmative obligation to provide any and all Brady-related material affirmatively. It doesn't have to be requested. It helps, but it doesn't have to be requested in order to create that obligation.
I understand the affirmative duty,
Okay.
but isn't there a duty on the defense counsel to request documents too?
I think it would dilute the state's obligation. But also there was a request for production of evidence in this case. It was very early on before the counsel that was ultimately trial counsel, because there was like a switch from original counsel to the trial counsel. But there was a request for production of evidence that was given.
Well, you're past your 12 minutes initially, so if you want to save some time for
Apologies.
rebuttal, you might want to go ahead and wrap up this portion.
Yes, Your Honor. Ultimately, this case was the result of a Brady error because the footage was exculpatory. It's a very low standard. The state withheld that evidence, and that delay in holding that evidence resulted in prejudice and an inability to use it effectively at trial. It was material evidence and would have resulted in a reasonable probability of a different outcome. And I will reserve the rest of my time for rebuttal.
Thank you. Mr. Maloney.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I think there are numerous points that I want to make in response to counsel's argument. I hope that I addressed them all in the brief. But I think first we do have to back up here. And with respect to the Brady violation, first of all, case law is clear that there's a distinction between delayed disclosure and actual evidence that is not disclosed at any point during trial. This is a situation that falls in the first category. This was discussed and came to light on the first day of trial, and then the prosecution did find the videos and showed.
Did you say the first day of trial or the last day of trial? Because I thought the counsel said the last day.
It was the first day of trial, Your Honor, when this issue came up during the cross-examination of Officer Johnson. That defense counsel cross-examined him about whether he was wearing a body camera, and he said yes, and then went on from there. And so then it was before his testimony ended that the defense moved for a mistrial, and then over the course of that evening is when the prosecution found those videos. The next morning is when the issue was further discussed. So this was.
So in the meantime, did defense counsel and the defendant have the opportunity to review the video and to have a little time to consider how they react, or what happened once the video got disclosed?
Right. So the following morning, the prosecutor informed the court that he had shown the video to counsel that morning, and then explained why he had not previously downloaded it. And then defense counsel responded that she had seen a portion of the video, the portion that purported to show Officer Johnson reading the PFA to the defendant. Counsel did note that the full video appeared to be much longer, and she renewed her mistrial request. And then that was when the court essentially said, look, based on what you told me, this not only would not be exculpatory, but it would actually completely shoot a hole in your theory of defense, which has been that he did not receive the PFA. So yeah, so it was basically the first day of trial is when the issue first came to light, and then the next morning was when the prosecutor showed what I guess would consider the meaningful portion of him showing the PFA to the defendant.
So your position is that this was not exculpatory evidence that would have been required to be unilaterally disclosed, that this would have just fell as a response to any discovery request that was made?
Yeah, I think it certainly falls in that category where, because it was turned over late. But yes, I definitely don't think, and certainly the district court was adamant in saying this was not exculpatory evidence, that this blows your theory of defense completely out, because it does show that the defendant did receive the PFA. Now, counsel has pointed out, well, here's how I would have dealt with that below, and essentially said, now I would have tried to use that to justify an instruction on voluntary intoxication or on mental disease or defect. I think that's kind of shifted throughout time. I think below, my recollection was this seemed to be more of a mental disease or defect argument, and now on appeal it's turned more into the voluntary intoxication. But the fact that the defense could have come up with a strategy to try to combat evidence that was harmful to its case does not make it exculpatory evidence. The fact of the matter is it shows the defendant being served with this PFA. So I definitely don't think it's exculpatory. It was turned over. And I absolutely maintain, as I did in the brief, that the defense's failure to proffer the video itself and to have that in the record on appeal, I simply don't know how we can get past that. He has to show that this was, for a Brady claim to succeed, obviously you have to show that it was exculpatory. That's the heart of what a Brady violation is. And I recognize that defense counsel did make a proffer below as far as the contents of the video. There was this brief description. And I'm not suggesting that counsel, in any case, is not allowed to make a proffer. And I'm not even suggesting that what counsel proffered was not factually accurate. But the fact remains, their whole argument on appeal is predicated on saying that this video was so important, and not only was it important, but it was exculpatory, that it would have affected the outcome of the case, because that's what they have to show, because it was delayed disclosure. It was not something that was never given to the defense. They did have an opportunity to use this. So they
Was there
have,
any request for a continuance, or, sometimes if evidence is belatedly disclosed, there'll be a request for a continuance for half a day or whatever?
absolutely, that's an approach that they could have taken. They could have chosen to, if they wanted to, they absolutely could have put that into evidence themselves and said, okay, now that we have this, we are going to use it in the way that counsel proffered they would. And I know counsel said, well, that would have been inconsistent with the defense that they had been running up to that point. But again, this was early in trial. It was during the state's case in chief. The defense had yet to put on any witnesses or evidence of their own. And we all know that parties are allowed to run inconsistent defenses. So to the extent that they wanted to, they absolutely, if they felt that this video was so important, so helpful to their client, they absolutely would have had the option, as Your Honor pointed out, to request a continuance and say that they needed a little bit more time to figure out how they wanted to handle it, or they could have simply chosen to admit it. But instead, they did neither. And again, I'm not...
Well, they actually asked that it be excluded, isn't that correct?
They did, as the alternative, exactly right. And that's,
Which was kind of a point of punishment against the state.
Yes, and I think a very reasonable alternative option that the court chose to follow there is to say, I'm not going to prevent the state from putting on witness testimony from Officer Johnson to say that he did serve this, but I'm also not going to let them play the video. And that gave the defense the opportunity to still continue to argue essentially that, well, we don't really know that he was served with this or that he was informed about it. So I think it was a fair solution by the court. But again, I simply can't understand how the defense is asking this court to find that this video was so important and that it was exculpatory without showing the video. Again, I'm not suggesting that trial counsel below was making anything up in describing it, but no person, no matter how articulate they are, is going to be able to describe a video where the key issue essentially is the defendant's demeanor, apparently. Whether he was acting so incoherent and it would show that he surely couldn't have been able to understand what he was being served with. Nobody can describe that as well as what you would be able to simply see if you watched the video. We've all seen people in various states of whether it's intoxication or if they're arguing drugs in this situation. There's not a one-size-fits-all standard here. There are people who are maybe a little bit intoxicated, but clearly still have a basic understanding of their circumstances and are able to understand and process the world around them, and something as simple as, this is a PFA, you're not allowed to go to your mother's home or to be around her. That's on one end of the spectrum, and then of course at the other end there are people who clearly would be much more incapacitated. And again, my argument is that there's no way that somebody simply summarizing a video showing a person's demeanor and mental state would be nearly the same as actually having the video. I do want to note, just in response to some other comments that counsel made at the outset of her argument, we also have in the record testimony and evidence from the victim saying that she had told her son on October 7th when he showed up at the house that he was not allowed to be there and that she had gotten this PFA. So while there was some testimony about things that she had done to try and help the defendant, sending clothing and perhaps speaking on the phone with the defendant, there's uncontroverted evidence that she had made clear to him the day before, at a minimum, the day before, she had told him personally, you can't be here. You can't be at this house. You can't be around me. So to the extent the argument is that this whole case hinges on the defendant not knowing, that's additional testimony in addition to what we had from Officer Johnson. But again, just to summarize, I think that the absence of the video, it is always the appellant's burden to designate a record showing reversible error. We know that this video existed. We know that the defense had access to it as of the second day of trial. Clearly, that would have been an opportunity, even if the defense for some reason didn't think to request a continuance at that point. They clearly could have said, Judge, we haven't yet seen the whole video, but we would like some time to do that, and/or we simply would like to proffer and put the whole video in the record at a minimum for purposes of the appellate record so that everybody can know exactly what this video shows. But instead, we have a panel of 3 judges and 2 attorneys up here who are just having to talk about a brief proffer, trying to figure out, well, what does it actually show? My position is that that's not sufficient and that that alone should be enough to defeat the defense's argument. But even if you don't want to go that far, I think that what we do have in the record from the district court level shows that this was not exculpatory. It was damaging evidence. There's a reason why that was the backup request from the defense, would be if you're not going to grant a mistrial, we would ask that you not admit the video in the record. You don't.
Earlier, counsel mentioned the decision by another panel of this court in Newsom, and she says it was an abuse of discretion for the court not to review the video before it determined whether a Brady violation occurred. Is that correct?
I'm not as familiar with, look, I was reading through the defense's brief as she was arguing, and her citation to Newsom was very brief and certainly was not that in depth. So I'm not as familiar as I should be, and I apologize with the facts.
Well, no. So my question is, though, if defense counsel on the second day of trial, after they had reviewed the video, asked the court not to allow it to be shown to the jury, did that eliminate the need for the court to review it if the defendant didn't want the jury to see it anyway?
I would argue so, and that certainly
That's
is.
what I'm trying to figure out this is kind of a fine point to me.
Right, no, but it's important, and I think that does crucially distinguish the case. To the extent that in Newsom, the defense was asking the court to review whatever video evidence there was, and the court simply refused to do so, then that's a lot different than a situation where here, I don't recall that the defense, first of all, ever specifically asked the judge to take the time to review the video himself before ruling on it. And then second of all, yes, when the defense then turns around and says, okay, my preference here would be a mistrial, but if you're not willing to go that far for whatever reason, then alternatively, we would simply ask that you not allow the video in. Then I think, yes, once the court has been faced with that alternative request and has decided, yeah, I'm not going to allow the state to admit the video, basically as punishment for not having turned it over before trial, then I think that does probably eliminate the need for the district court to review the evidence at that point. But I don't think it absolves the defense of the responsibility to at least put the video in the appellate record if they're wanting to now argue that this was such a critical piece of evidence in their favor. But again, the very fact that their backup request was exclude the video, I think says all we need to know about the contents and whether it was exculpatory. I'm not a trial attorney, but I can't imagine if I was holding on to a piece of evidence that I felt was, aha, this favors my client, that I would then say, Judge, this is such good evidence that I don't want you to show it to the jury. I don't want anybody to see this, so please exclude it. So I think that does speak volumes about what this video actually showed and whether it was favorable to the state or whether it was exculpatory, as the defendant would have this court believe. I think I've touched on all of the points that I plan to today. Again, I would just argue that in this decision, the district court, I think, came to a reasonable and fair compromise. This wasn't something that was disclosed after trial. It was presented during trial. It gave, I cited in the brief, the Breitenbach case, I believe, where on the second day of trial, the defense was given a fingerprint report and on appeal tried to argue that that was a problem and that that was a Brady violation. And I think the Supreme Court essentially said here that it wasn't that it wasn't disclosed, it was disclosed. The defense had an opportunity, and in that case they did say specifically one thing they could have done was ask for additional time, or they could have used it themselves. And I think that's very much the situation that we're in this case as well. I'm probably at my time, so I would just sum up by asking this court to find that the district court did not err in its handling of the matter and ask this court to affirm the district court. Thank you.
Ms. Hogan?
If I may proceed.
Yes, you may proceed.
Your Honors, I think that the fact that she asked as an alternative that this information, this footage be excluded is due to the fact that a trial counsel at the penultimate moment, where only one single witness is left to testify, that witness was not present when he was served allegedly with this document. She had to weigh the loss of credibility that she would experience as trial counsel and our client facing incarceration for a long period of time. She had to weigh the effect of that loss of credibility from immediately changing and suddenly changing her entire defense strategy. She had to weigh that loss against what the effect would possibly be otherwise. And so because she had been pursuing a defense strategy that was based on the lack of service by itself, excluding that, if the trial court wasn't going to grant a mistrial so that she could pursue that evidence for a voluntary intoxication defense, this was the next best alternative rather than losing a substantial amount of credibility as trial counsel and for the defendant.
So it was trial strategy because it was this video, we don't know exactly what it shows, but it sounds like it could have been a two-edged sword because on the one hand, it's going to show he got served. On the other hand, may or may not be exculpatory, but it could have showed that he was not of sound mind when he received it.
I think that actually also goes to another error of fact of law that occurred here. It seems that the trial court was interpreting it as entirely inculpatory because he was given this document based on what the strategy had been thus far. And the strategy thus far had been that he had never received that document, he was not served with that document. So the trial court was reviewing this footage from that lens of what was your defense so far and not looking at it of what could it have been used for had it been provided before trial, because a Brady violation is really a violation of your pretrial rights, so that it can be used effectively at trial. So rather than looking at it from that lens of how could this have been used had it been provided with sufficient time to be effectively used, it looked at it from, we've gone through 4 witnesses that the state had provided with one defense strategy and suddenly changing it. So I think that just compounds the issue. And then the fact that the trial court allowed a last witness to testify to kind of build up the state's case that he had been served. That person was never there when he was served. She couldn't be cross-examined about this footage at all. And that means that it could not have been effectively used.
Are you talking about the late endorsement of a witness?
Yeah, I think that it kind of compounds the Brady issue because it was used to prop up Officer Johnson's testimony when he was successfully impeached on the service document. The state wanted to introduce that last witness to prop up his testimony, but because she wasn't there when this footage was being filmed, she couldn't be cross-examined about that footage at all, so it was literally not able to be effectively used at trial.
What is your response to counsel's argument that your failure to proffer and produce as evidence the video defeats your Brady claim?
I think it still goes back to Newsom, that we start from what did the trial court do before we even get to what was in the appellate record. And the first question that we ask is, what did the trial court review? It did not review the footage, and it had an obligation to. And under Newsom, which is a published opinion of this Court of Appeals, the district court was required to make findings of fact based on that footage, and its failure to do so is an abuse of discretion, which requires a new trial.
So, but if the defendant it's requested the court not to admit it to the jury, why would the court need to see it?
Because he had already denied the mistrial request. And so this was a secondary, like a backup plan, because all of the judges, all of the trial courts' statements that thus far had been indicating this is gonna get denied. He's not gonna get a new trial so that this information can be used effectively. So what is the least harmful alternative? I guess it is to exclude it because I don't want to lose credibility in front of this jury. My client's interests are at stake here. And so I think that was just a backup plan. I think the fact that this mistrial was denied without reviewing that footage is an abuse of discretion by itself. If this court has no further questions, I would rest our case and request that this panel find a Brady violation occurred and that Mr. Sawyer deserves the right to a fair trial and a new trial. Thank you.
Well, thank you both, and we will take this under advisement and hopefully get an opinion out to you pretty soon. And we are adjourned.
Thank you.